they are transferred, then the students will suffer. Then they are interested in getting transferred. In this matter,
My lord, I'm only indicating this is the ground reality. She is the single teacher.
I can understand.
My lord,
The
if some preference could be given, my lord, because
you file it in the department, and when the list will be published, you then mention for upgradation.
my lord,
Yes.
is it possible, my lord, to so that the matter can be kept on Tuesday, my lord?
File it in the department. Yes,
I'm grateful.
please.
Yes, yes. One hand.
Not half of the petition. Initially, the REIT application was filed on different ground. The petitioner was on leave on medical ground. Thereafter, she was not allowed to join. I approached this normal court, pursuant to the order of this normal court, she was allowed to join. During the pendency of the REIT application, pursuant to the order of this honorable court, petitioner made an application for transfer. Because the school is a coastal area and she is the resident of Damdam. That application was made, that was forwarded to the DI, and this honorable court directed the DI to ascertain a vacancy as for transfer of the petitioner. I have the instruction, they have already ascertained a vacancy, and there is a direction to file a report upon the DI, madam.
But here, Lord, see, REIT petitioner absent from the Lord, see, last 10 years. And as per the court order, Lord, see, join the duty, Lord, see. Thereafter, Lord, see, as per the DI report, there is no vacancy at all in the single teacher. Thereafter, Lord, see, directed to the commissioner. Commissioner also file a report. There is no vacancy at all. Here, Lord, see, one vacancy is there, Lord, see. I have received one vacancy that as per the DI report, Lord, see. Kindly see the Lord, see. Local arrangement, Lord, see. Local Lordship, I am not received any vacancy, but one vacancy Lordship, I have received Lordship. That Lordship petitioner is agree, then Lordship join there. नहीं तो बोले ही दिलो willing there is
There is a vacancy.
recent.
Commission, a vacancy has been identified. Has this been intimated?
But here Lordship, I have the file a commissioner report. DI report also.
No, anyway, since a vacancy has been identified, why is it not forwarded to the commission? What is your report? You are directed to file a report.
No, upon the commission.
Respondent number 3, who is the respondent number 3?
He is the DI, my lord.
Here Lordship, on the school,
He is the
Lordship,
DI.
the single teacher.
DI is the...
But he is the single teacher, Lord. If the Lordship, he is transferred, Lordship, there is a school is the Lordship, no teacher is the steady, Lord.
Then the law takes care of it.
Lordship,
Please
yes,
come.
Lordship, yes, for the Lordship.
The District Inspector of Schools, Secondary Education, North 24 Parganas, has filed a report signed on 12th February.
One DI, one Lordship, two DI report.
2026. Is it dated 25 or 26? 25.
25.
12 to 25.
Yes.
More
Yep.
than 1 year has elapsed. Is the vacancy still there?
If the Lordship is not agreed by the petitioner, there is Lordship is the 1 year has been passed, Lordship. The matter was hard time to die. Last Lordship is the 3 years.
Yes.
3 years, Lordship. If the Lordship single teacher, not willing teacher, I am not received any willing teacher. Thereafter, Lordship.
Moreover, whether this vacancy has been utilized in the SLST.
Don't know because it's more than 1 year old.
Then will be necessary.
Report dated such and such, wherefrom it appears that a vacancy as on 12th February 2025 in the post of history in the normal section of Modhamgram High School within bracket HS has been identified. Stop. Paragraph, let the vacancy, comma, the if available, comma, be forwarded to the School Service Commission for recommending the petitioner in the said school. Stop. Then what remains? Nothing remains.
My lord, instead of
Disposing,
of the matter
I'll keep
today,
it pending.
come back with the instruction
Alright.
that whether
Let's
the
say
vacancy-
willing teacher, let's say there is no willing teacher till.
Doesn't
That's
matter.
their point, but our point is that if the court directs, I have to check whether the vacancy has been earmarked
Yes.
for any selection process or not.
Well, released on 6th of March.
Deeply applied.
So my report is kept in the.
Single page report is kept on record. You want this to be written with the records
Not-
also?
Willing teacher. Yes, Lord.
এটাও রেখে দেবেন।
On prosecution. This is the instruction, madam. I see.
My lord, I'm appearing for the state.
Her grievance has been redressed, my lord. She has obtained the documents.
Learned advocate for the petitioner submits upon instruction that the grievance of the petitioner has been redressed during the pendency of the writ petition. Stop. The petitioner has forwarded a written communication to the learned advocate on 18th of December 2025, praying for withdrawal of the writ petition. Stop. Next. In view of the above, the writ petition stands dismissed as not pressed. Photocopy of the written communication of the petitioner filed in court today be written with the records.
Grateful, my lord. Obliged.
My lord, I appear.
Is appearing for state. He is on his leg before courtroom number 24. I am praying for short pathwa. Kindly keep them.
Who are the others?
Mr. Bandyopadhyay and Miss Devolina.
And
Miss Devolina.
call her.
They all are engaged in courtroom number 24.
Call.
I am praying for short pathwa. Kindly keep it.
What is your prayer? Is it against the state?
It's against the state.
What is your prayer?
My lord, I have four. My lord, I would pray for four specific directions. In the earlier round, there was an earlier round of litigation where where coordinate bench of this honorable court has directed that the teachers of normal section, petitioner is an association, my lord. Teachers of normal section cannot be demoted from their status of normal section. My lord, previously before first SLST 2016, my lord, teachers were appointed from class 5 to 10. And my lord, thereafter, my lord, in 2016, they started to categorize the teachers from class 6 to 8 and 9, 10. So, my lord, petitioners at that point of time approached this honorable court, the association, that this cannot be done because they were already appointed for the teachers of class 5 to 10 because their status will go and my lord, qualifications are also different. So 9, 10 my lord, qualification is different as well as my lord, 6 to 8 qualifications are different. So my lord, the Honorable High Court, my lord, at page 23 it starts. The relevant portion is 25.
Yes.
My lord, kindly see the second last paragraph. May I just read it out? In view of such submissions being made on behalf of the state respondents, it has been amply clear that the grievance of the members of the petitioner association, as has been ventilated in this petition, stands redressed, and they cannot be demoted from their status as assistant teacher in normal section to the assistant teacher of upper primary section. This was the direction passed by the High Court. After the High Court passes the direction, My lord, thereafter on 13/9/2022, my lord, that is at page 27,
Hmm.
the government accepts it and pass an order.
Hmm.
My lord,
Yes.
kindly see first, second, third line from the middle.
Hmm.
The matter has been examined and it is clarified that the status of the teachers already appointed in normal section of recognized aided sponsor school will remain so, and they will be treated as teachers in the normal section. Well, this was done by the
Hmm.
state government.
Hmm.
Now, my lord, what happens is page 28, again, my lord, in the year 2025, at the district level, my lord, they are taking, my lord, UDICE portal. My lord, that is data collection. It is full form is Unified District Information System for Education. Here, my lord, when some teacher is going into the portal, page 29, your lordship would find there is no, that is column point number 3.316 appointed for level. My lord, there in the drop down, my lord, there is no normal section in many of the districts. And some of the teachers, my lord, were compelled to give the option here. They could not get anything. That was a specific direction by the High Court. Now, my lord, what I pray as of now is, before your lordship, 4 directions, my lord, that is to circulate the clarificatory memo and the High Court's order to all head teacher, SI, DI, so that the same can be implemented. Separate category in the UDICE portal as normal section. A direction to call for resubmission of the UDICE portal for the teachers of class appointed before first SLST 2016. And my lord, fresh approval for all those teachers. That is, my lord.
Page 28, I see this is dated 9th of October 25, and the last date to fill up the forms was 8th of November. Right?
Yes.
Now, why are you coming so late?
My lord, the difficulty was, my lord, this started throughout the West Bengal. Some of the districts, my lord, kept pending. Some districts have done it. This was the condition. And there is a specific order of the High Court. We approached different district inspector of schools in different districts, but there was no use. That is why, my lord, I have come up before your lordship. Because the service career will be gone. My lord, I just specifically want, my lord, prayer B, prayer D.
By the change of status, are you losing anything financially?
No, my lord, the difficulty would be by the changing of status. The main problem would be the qualification is different. Now, for class 6 to 8, your lordship knows the TET is mandatory. 9, 10, my lord, if I have B.Ed, it is not required. Now, the status gone means everything gone. Subsequently, my lord, 9, 10 salary will be increased. So, I am having a status of 5 to 10 teachers, and it is admitted by the state, order passed by this honorable court, as well as, my lord, that has been implemented by way of that clarificatory memorandum. The teachers appointed before 2016, before the first SLST. In West Bengal, the system was normal section. There was no categorization of 6 to 8 and 9, 10. Now the categorization have changed, and that has been accepted by the state.
Yes.
We are yet to receive instruction with regard
We
to
means who are you representing?
Mr. Shishanna Bandyopadhyay, my lord, is appearing on behalf of state, my lord. The schools, I'm not representing the School Service Commission in the matter, my lord.
Are you there in the state panel also?
I am, my lord, but I am not in this matter.
All
My
right.
lord, Mr. Bandyopadhyay has short instructions from the offices, my lord. They are yet to give us instruction.
right.
My lord, we'll come back with the instruction. And with regard to normal section, my lord, just they are being protected by the order of this court, my lord.
Right.
And
And the your department, these
on
act accordingly.
my lord, we will, my lord.
Right.
We'll take instruction, my lord. We'll apprise your lordship about the facts.
Please come. The petitioners are aggrieved as the UDICE portal, UDISE, does not have a provision for the level within single quote normal section teachers. Stop. The issue came up for consideration before the court in WPA 19133 of 2019. Party num, page 23. Wherein video order dated, is it 20th?
26th.
20th July 2022. The court was pleased to record the submission of the state respondents that the teachers in the normal section cannot be demoted from their status of assistant teacher in normal section to the assistant teacher of upper primary section. Stop. The secondary branch of the school education department published a memo clearly mentioning that published a memo clarifying that the status of teachers already appointed in normal section of recognized aided/sponsored schools, will remain so, and they shall be treated as teachers in the normal section. Stop. Teachers to be recruited for upper primary section/schools under upper primary recruitment rules, 2016 will be treated as teachers for upper primary schools. Stop. Direction was passed for modifying the technical provision in the portal. Stop. Paragraph. The petitioners state that the UDI's entry, which started in October 2025, does not have a separate provision for the assistant teachers in the normal section. Stop. Prayer has been made to direct the authority to update their portal in such a manner that the status of the assistant teachers of the normal section is not demoted. Stop. Paragraph. Learned advocate representing the state respondents seeks time to revert with instruction. Stop. Paragraph. As it appears that the state government has already disclosed its stand that the status of the teachers in the normal section will not be changed, the portal ought to be modified accordingly in terms of the memo of the Joint Secretary, School Education Department, Secondary Branch, dated 13th of September 2022. Stop. Release the matter for further consideration on 6th March 2026. Stop. The state shall file a report disclosing the manner in which the direction passed in the memorandum dated 13th September 2022 has been implemented. Stop. The status of the assistant teachers in the normal section of the school shall not be disturbed till 20th of March 2026 or until further order, whichever is earlier. Let the junior members open their mouth and make submission. You all stay behind. Otherwise, they will never learn. You should give them the opportunity and make them work hard. Get it?
Let affidavit of service be kept.
Yes.
I'm good.
My lord, I have for the petitioner.
For the state, as per your order here, submit the
Why, despite repeated requests, the DI did not forward the instruction to you? Did you take instruction?
yes.
Just wait.
Some problem is they send me the instruction to mail, but not inform me. And many times instruction is.
Whose fault is this? A mail will be communicated and then a phone call will be made. Will you not check up your mail to whether you received instruction or not? And you blame the person concerned? This is not good. You should have updated yourself and you boldly submitted before the court that the DI is not passing on information.
I don't know. Last of all, he give me the instruction.
Yes, what is it?
My lord is totally.
And he was directed to remain virtually present. Why is he here personally? He was not directed to come here personally.
I told him, but there's some problem, some server problem, then he come.
Server? What does a server got to do with this?
Some problem in the connection.
Has the problem of the petitioner been resolved?
Not yet, ma'am.
Already payment, I submit the instruction. They already payment the 8/5/2023 the pension is totally all the school authority. They not submit the no objection certificate.
School authority issued the no objection certificate in favor of the petitioner in May 2023 and his retirement benefit was disbursed. So there has been delay between the dispute between the school authority and the petitioner. Yes.
Lord, as of today, my lord, the interest part has not been disbursed in my favor of my client, my lord. So, my lord, I have before this court, my lord.
But the problem is not with the DI. The problem was with you and your school. Why will the state bear the responsibility?
My lord, the school comes within, my lord, the authority, my lord, the teacher in charge, TIC. My lord, last occasion we have to file a writ petition for the e-pension, my lord.
Yes.
My lord, I have annexed the order, which is page 19, annexure P4. The order of my lord Justice Vishwajit Basu, my lord.
Yes.
Here, my lord, it has been specifically written regarding this e-pension, the no liability certificate. Page 25 is the relevant portion. After generation of e-PPO or the last date of service, whichever is latter, the head of the institution, sub-inspector of the school, shall transmit the no liability certificate to the pension sanctioning authority online using DSC after entering a service data. The PSA shall provide the same using DSA after entering the necessary data at the end within 3 days from the date of receipt of it.
So in terms of the court's order, the no liability certificate was issued.
Yes, madam.
Right. Now it is the teacher in charge who created all this problem.
My lord, even they did not, we have regularly communicated to the DI office, the teacher in charge of that particular school, my lord, but nothing has been done from that end, my lord. Even the DI has not taken any steps for ensuring the pension part, my lord.
Pension part means?
Pension, my lord, the pension and retirement benefit part, my lord.
Without this document, it could not have been given.
But they ought to have talked with the, my lord, at that.
Yes, let me hear. What is the problem? Why did the teacher in charge not issue the no liability certificate in favor of the petitioner?
The teacher in charge told that several
works had not done that HM. So several times Honorable Court directs the HM to complete
no direction upon the district inspector of schools to remain personally present, comma, but the DI is present in court personally. Stuff. It has been submitted that the very day the no liability certificate was issued in favor of the petitioner by the teacher in charge of the school, comma, the amount mentioned in the PPO was released in favor of the petitioner. Stuff. The DI is no way responsible for the delay in disbursing the terminal dues of the petitioner. Stop. Paragraph. The TIC is not represented. Stop. Let notice be served upon the respondent numbers 5 and 6, intimating that the matter will appear in the list on 6th of March 2026. Stop. The school should be represented on the adjourned date. The learned advocate for the petitioner and the district in charge, district inspector of schools shall intimate the respondent numbers 5 and 6 about the next date of hearing. Instruction by the District Inspector of Schools, Secondary Education, Purva Bardhaman, dated 12th February 2026, be written with the records.
Okay.
You are not required to remain present. You can go. There was no direction for you to come. Why did you come?
Actually,
You could have joined virtually. Yes, next.
I beg to appear on behalf of the petitioner. May I? Or may I file my affidavit of service?
Oh, 255. Yes.
The petitioner was a school teacher, retired on 31st December 2018, my lord. Thereafter, retirement benefits were not released in favor of the petitioner. Thus is writ petition. My lord, I've made representations, my lord. The petitioner had exercised the option of pension as well. I have a certificate from the administrator of the school that is at page 21. But retirement benefits, none whatsoever, have been released till date.
Provident pension, provident fund হয়নি কিছু হয়নি এটা একটা এফিডেভিট আছে না হ্যাঁ এফিডেভিট করা আছে
আচ্ছা ডিসমিস ফর ডিফল্ট হয়েছিল যেটা নেই তো এটা
দুটোই নেই হয়েছে
What is your prayer?
My prayer is at page 16, my lord. I will
Consider the representation.
consider the representation. Yes, consider the representation. Prayer D is also there, my lord. Prayer C and prayer D is also there, my lord.
Petitioner is governed by the GPF.
My lord, will kindly come to page 21 for once.
Yes.
This is the certificate by the administrator of the school. This certified that Malvika Giri, this is the petitioner, exercised the option since file number for pension, including family pension cum gratuity on 36 to 1990 as per photocopy of the option as submitted by the teacher. But as per the acquaintance rule, it is observed that PF subscription was deposited in favor of the teacher till February 1990 since her date of joining. 10/12/79. Not only that, but the PF subscription at the rate of 6.25% of the basic pay was also deposited for the first time on March 1990. This
Yes,
is the
thereafter it was not deposited.
this is the certificate.
Which is it says that it's
Right.
only first time, it's only on March 1990. You want to shift over to the GPF scheme.
My lord, that. But nothing has been. I have not got a single penny as retirement benefits.
How can you get? You are not there in the scheme.
And will kindly to the first portion.
There was a time period mentioned within which you could have opted. You also did not opt for that. Please come. Yes, what is your submission?
My lord, this matter was, my lord, dismissed for default for some time.
Yes.
My lord, there are some, my lord, other papers, my lord, which is now lying with the, my lord, I'm just handed over to the London GP, my lord, because he is leading me in this matter. My lord, I have to take instruction. I have tried to contact, but my lord, I cannot. Lord,
There is an usual order where the court is directing
yes,
the
that-
authority to consider whether the teacher can be permitted to switch over from the CPF to the GPF, provided money and everything is
but
returned.
every judgment is there, my lord. Shefali Jana, I have appeared, my lord.
Yes.
We have.
Right, please come.
But in that case, that the representation may be considered.
CPF to GPF আমাদের একটা ইউজুয়াল অর্ডার আছে। হ্যাঁ, হচ্ছে মুক্তিময়ী পাল।
জাজমেন্ট হয়ে গেছে এরকম। যে টাইম ফ্রেমটা ছিল
মুক্তিময়ী পালকে রেফার করে
সেপ্টেম্বর অবধি
এটা একটু দেখতে হবে।
মুছে ফুছে গিয়ে অনেক ইয়ে হয়ে গেছে।
Disposed.
My lord, directed to consider.
No, there is an usual order. If he pays, then it will be refunded. Yes, next.
My lord had directed. I'm extremely sorry.
Yes.
My lord had directed me to
Check up the order in the server. 490.
490, I'm saying not today, Lordship.
Why?
Mr. Bongshibodhan Maiti is advocate on record. He has some personal difficulty. He has not come to the court today.
See, after so many days, these matters are taken up and you all are seeking adjournment. What is the use?
He's instructed me over phone, Lordship. Kindly make it not today.
23 matter. Releasing area claim of the petitioner. Only not today.
I'm grateful. Full 91, my lord. I am for the petitioner, my lord. Interest of gratuity plus revised PPO. My lord, this is the lordship order, my lord. And sign.
Revised gratuity and area pension.
Yes, my lord.
Area pension.
No, we are claiming interest
Interest on what?
for 2 years, from 2018 to 2020.
Yes.
Page 12, the revised PPO is there. You want interest on what?
For late payment.
Guys, revised gratuity and pension. And revised gratuity and area pension, my lord.
Where is the area pension? Are you sure there is some area in pension?
Yes, my lord. Page 8.
Page 8.
Area pension.
Oof, the prayer is there. I have seen. You show me where is the area. Come prepared. Come prepared. Not today.
My lord, same matter, my lord. Petitioner retired, my lord, 31st January 2070. My lord, PPO issue, my lord, 3rd May 2018, first PPO. And second PPO, my lord.
And you have filed the writ petition in 2024.
Yes, my lord. No, my lord, say revised PPO, second, my lord, 26th November of September 2023.
So your grievance is with the first PPO or the second PPO?
Revised PPO, my lord.
23, if the you have a problem with 23, then you do not cite the first PP of 2018. You cannot cite that.
No.
Why are you looking at her? You are doing so many matters. By this time, you should know what the law is.
No, my lord.
You've forgotten.
My lord.
What? You want to come prepared?
My lord, revised PPO, my lord, 26 September 2023, my lord. I want interest of revised PPO, my lord.
Revised area pension. You've got similar order. Let me see.
No, my lord.
রোপা 19 আপনি পেয়ে যাবে আমাদের রোপা 19 disposed.
My lord. I am from the petitioner, same matter, my lord. Deploy from service, my lord. 28 February 2019, and first PPO, my lord, 17 December 2019, and second PPO, my lord, 14 March 2022.
রোপা 19. Who is the other side? Service দিয়েছে তো? Next. আগেরটায় দেয়নি? Where is the service in the earlier matter? 492 service দিয়ে দিয়েছি। দেখুন দেখুন।
আচ্ছা, নাম্বারটা একটু বলবেন?
রামরঞ্জন ব্যানার্জি।
Four 493, my lord, single PPO.
ঠিক করে দেখুন কোনটা হচ্ছে।
Interest of gratuity, my lord, single PPO.
Only gratuity?
Yes, my lord. Gratuity and area pension, my lord. Date of retirement, my lord.
All right, I've seen. Next.
My lord, single PPO, petitioner himself. Retired from service, my lord, 28 February 2019, and PPO issue, my lord, 17 December 2019.
Disposed.
We do is a petitioner, my lord.
Kindly see the para 10, page 5. Here stated, petitioner husband died on 5th March 2017, my lord.
Yes, ma'am.
And here stated, hence they have enjoyed the interest for a long time.
And hence?
Hence they have enjoyed the interest for a long time. The claim for area change.
Yes. These are the first part of the revised gratuity 2017. Open and visible interest on the business. You want it on the revised one?
Only, my lord.
Revised. Disposed. 2019 ROPA.
That is my affidavit, Lordship. Her Lordship, petitioner was appointed in the year 81 as Group D staff, Lordship. In the as organizing staff, Lordship. Yes. So, Lordship, several times, Lordship, DLIT inspection held. And lastly, Lordship, 2002, DLIT inspection held. And thereafter, the school was not recognized, for which the school authority filed writ application. And in terms of the court order, Lordship, petitioner appointed in the year 2012. And retired, Lordship, 30th June 2018. There is shortfall for an order. I have corrected the order.
That shortfall is 4 years, 4 months. Whatever the school got recognized in the year 2012.
See, for the delay
Now,
of
all the teachers now, if they come up with the same prayer, now the shortfall is, the state can condone up to 6 years.
6 years?
Sorry, 6 months. Very sorry, that's 6 months. Now it is 4 year and 4 months. 27 days, nearly 4 year, 5 months.
Is the petitioner standing in the same footing of Kalipodo Jana, page 78? Is it the same school?
No. Another school.
Or it's a different school? Where is the DLIT? UNX DLIT?
No, Lordship.
Then?
I have stated, Lordship.
Where have you stated?
Para 5.
When did the school got recognition?
Lordship, 2012. Case was filed 2004, Lordship.
You file a report.
My lord, I have got a,
Please
my lord.
give.
বার 10-এর অর্ডারটা আছে গো দিদি, ওটা একটু দেখি 24 বার অরিন্দম সিনের অর্ডার অ্যানেক্স করেছে।
Lordship, similar identical order I have annexed in the writ petition, Lordship. There is a
Identical cannot be, my lord, identical because it depends on a case to case basis.
You have a copy of this brief fact?
Yes.
The first paragraph, I see a writ petition number of 2004.
Yes, my lord.
What was the date of the order?
Date of the order is 24th, my lord, second paragraph.
24th of December 2010.
24th December 2010.
And
the school, the board was directed. Board of the second
recognition granted in December 2012.
2012.
Right.
Yes.
Then,
my lord, that petitioners, the teachers, my lord, got approved with effect from 27th November 2012.
When did the petitioner retire from service?
Yes, next page, 2018.
So, according to your brief facts, the petitioner joined in 1981. Why?
Is an unrecognized school.
So what?
Then my lord, this way, my lord, the teachers and all other teachers will be that coming up saying that that's shortfall. And had it been, my lord, a case of 6 months, and government power is to up to 6 months only. The law says. Their right accrues from the date school got recognized. Even if it is not a case that school got recognized in 10, 11 and they got their approval from a subsequent date. This is not a case there. From the date of recognition, they have been approved.
There is an order of the coordinate bench, page 78.
Yes, my lord.
Did you challenge this? and the far less challenging this order has been complied
Point of
with.
Supreme Court, there are told page 74 is the division bench order.
The Principal Secretary complied the order. Page 81. Kalipada Jana.
Yes, lords. More than 2 years.
I just Kalipada Jana's shortfall is of 2 years.
More than 2
2 years, 5 months.
Relying on the judgment lordship Kartik Chandra Das. Kartik Chandra Das more than 5 years, about 5.5 years. I have the PPO of Kartik.
This organizing teacher case is also involved. And my lord, in division bench, it is a settled position, my lord. If your lordship, my ladyship directors may come up with that, this organizing teacher concept is a history now. It cannot be banked upon on this organizing teacher concept. Passed one of the judgment I can recollect that's passed by Honorable Justice Rakesh Tiwari, sitting with Honorable Justice Mir Dara Seko as their lordship then was. Yes, yes, yes.
Kartik Chandra Das qualifying service lordship 4 year, 10 month, 4 year and 10 month lordship. Same and identical matter.
It is a bona fide organized Kartik Kalipada Jana. It says from the my lord, that is a organizing
Kartik
teacher.
Chandra Das, division bench's order.
Yes, yes, yes. But
Same
there is
thing.
other judgment also, my lord, that organizing teacher concept, and here is not a petition is not the organizing teacher.
Staff lordship, group D staff.
Or organizing staff is not applicable for an unrecognized school.
Group D lordship, how?
Has your case been considered at all by the authority? No.
No, lordship.
Did you make any representation?
Yes, yes, lordship.
Where is it?
The 57 page.
Please come. The petitioner seeks. The petitioner seeks pension. Stop. There is shortfall of 4 years, 4 months and 27 days in his qualifying service period. Stop. The petitioner submits that he has rendered more than 38 years and 8 months in service. And 8 months in service. But as the school in question was not recognized at that point of time, the entire service period of the petitioner has not been considered for calculating his pensionable service period. Stop. The petitioner has relied upon order passed by the Honorable Division Bench of this court in the matter of page 74, FMA 677. Stop. The petitioner has also relied upon orders passed by various coordinate benches directing the employer to take into consideration the service period of the employee in the unrecognized school. Stop. The all right. Similar order for consideration of the representation.
My objection may be recorded.
Your objection is recorded.
Hmm.
My lord, I am appearing on the state respondent. My lord, kindly allow me to join, my lord.
Who is for the petitioner?
498
My lord, in this matter, actually, my lord, in 2024, I got instruction that regarding his pension file, there was some objection. File returned to the school authority. Petitioner is required to, my lord, comply with those objections. And till date, we have not received any, my lord, pension file from the school authority after getting rectified by the school authority.
None appears on behalf of the petitioner at the time of call. Stop for ends of justice. Release the matter on 2nd of March.
My lord, instead of 2nd of March, my next week, my lord, I will not be available, my lord.
When will you not
2nd
be
of March.
available?
My
Doesn't
lord,
matter. If
my lord,
the-
I have, my lord, some, my lord, family function, my lord, on
Let
that
it
day.
remain.
So, my lord, it will
499.
not be possible, my lord. My lord, kindly excuse me.
499. Yes.
There is the overdraw matter, Lordship. I have corrected Lordship order.
Who is for the state?
Lordship, I am from.
What is the instruction?
Lordship, I have to take instruction, Lordship.
Why? Why is it not ready? If in 2 years back, this writ petition must have been served upon you.
Lordship, Lordship.
Then it should have been here.
Just give me 1 day, Lordship. Come back.
For 2 years, you couldn't take instruction, and for 1 day, you will get instruction. The petitioner seeks refund of the overall amount.
Yes, Lords.
That was recovered from him after his retirement. Stop. The
Before retirement, he deposited, Lordship. For about 6 months.
the DI is directed to revert with written instruction on the adjourned date, 2nd of March. Service is taken on record.
And for the petitioner, Lordship, he is also her.
Who's for the state?
I do not know, Lordship. I have sir. Her is more corrected copy, Lordship.
Right, same order.
Regarding item number 498, I appear for the school, but I just missed it.
Has any order been passed? 2nd March.
Well, my name may be for the school.
Where is the Wakalatnama?
I have already filed. I appeared earlier.
All right.
Great.
I'm on behalf of the student, my God.
What is the matter?
Finish the last one.
You for the state?
Yes.
What is the instruction?
Not yet received, my God.
Not yet received? 2020-24 matter not yet received?
Try to contact it, but not yet.
What is your prayer? Obhijit Boito is annexed over here.
Peculiar prayer. The
Peculiar.
the father of the petitioner was assistant teacher. Prior to their mother died, prior to his retirement. Father of the petitioner moved a writ petition, and in Obhijit Boito's case, he was one of the parties. It's the judgment. That has been recorded in the earlier order. Prior to judgment, my lord, he died.
The son also died?
No, father died.
Father died?
Teachers.
So
now the widow also died prior to that. Now the son has come to return the money and to get the area pension. Since the judgment has been delivered in favor of also, their father Sushil Boiddo was that has been recorded in the earlier order also. Kindly see the order.
Very well. The order that we are passing, regular usual orders where the heirs are coming to refund the amount, that order can be passed.
That order can be passed.
Right.
Subject to refund and
subject to refund, this can be done. You do not have? Hey, Pradeep? Pradeep? Next time, phone should be outside. With additional interest in terms of May 2014 notification. Yes, sir. All right.
5, 6, 4.
Mr. Shaha, you could not get instruction?
My lord, yeah, in that event, my lord, let it be taken up.
That event, it is disposed of.
Lord.
Next.
For the petitioner. I'm paying for interest on revised PPO lordship.
Revised area pension and revised gratuity?
Yes, lordship.
Disposed. Service is taken on record. Pradeep. Yes.
My lord. In interest and gratuity, my lord. Revised PPO, my lord. This is a retired from service, my lord, 30 September 2017. First PPO, my lord, 6th September 2017, and second PPO.
Where you have a copy of the suggested order?
Oh, my lord.
You want revised area gratuity only or pension also?
Gratuity and area pension also.
All right. Disposed. Senior
Same matter. Same matter, my lord. Petitioner retired from service, my lord, 30 November 2018. And first PPO, my lord, 12 November 2018. And second PPO, my lord, 2nd March 2021.
That is not annexed in the writ petition.
Which one?
Well, 21 PPU.
Page 12?
No, 12 is.
Page 12, my lord.
Oh my, sorry. Excuse me, my lord. Excuse me, my lord.
Yes, disposed.
Same matter, my lord. Area interest of gratuity plus area pension, my lord. Revised PPO. Retired, my lord, 30 November 2018. First PPO, my lord, 2nd November 2018. And second, my lord, second PPO, my lord, 28 January 2021.
Disposed.
$507, my lord, over 12, my lord, by Treasury channel.
Why will this be allowed? Why will this be allowed? The payment was made in the year 2020. You retired in 2022. So the authority had enough time to rectify the mistake. Please come. The petitioner seeks refund of the amount paid by him allegedly on account of overdrawn payment. Stuff. It appears that the petitioner refunded the amount by way of treasury challan
More than 5 years, my lord.
in January 2020. Stop. He retired from service on 31st of October 2022. Stop. It appears that the authority, on detection of the error in pay fixation of the petitioner, rectified the mistake during the service tenure of the petitioner and directed refund of the overdrawn amount, which the petitioner did by way of treasury challan. Stuff. In the year 2024, the instant writ petition has been filed claiming refund of the amount paid. Stuff. The court is of the opinion that the employer can certainly rectify the error in pay fixation well within the service tenure of the employee. Stop. Employee stop now. And direct refund of any amount paid in excess. Stop. In the instant case, the error was detected long prior to retirement. Stop. The writ petition filed more than 2 years after retirement, seeking refund of the same cannot be entertained. Stop. The writ petition fails and is hereby dismissed. Return this.
It's five.
I'm appealing for the status.
Interest of gratuity, my lord, single PPO. Petitioner retired from service, my lord, 31st March 2023. And my lord, PPO issue, my lord, 11 September 2023. Single PPO.
Disposed.
Yeah, I am appearing on the affidavit of service. As a petitioner, I am also praying pension by refunding the government share with interest and additional. Petitioner retired January 2018. Yeah, he opted option as per circular 2014, 17 June, and deposited money thereafter within not time after 4 months. That's why he's not release pension. He's only got the CPF money and gratuity. Thereafter, I deposited challan. Thereafter, I withdraw. Now
I did not follow. You deposited the money and then withdrew it.
now deposited, but they have not considered since I have not deposited
Within time.
within time.
Yes.
So authority had not released the pension.
Yes.
After some retirement 1 year, I withdraw the money.
Yes.
Now I am paying lordship as per
No,
decision.
sorry. How many times? You'll pay, you'll withdraw, again pay.
I know, as per order of the honorable court, kindly see.
Why? Where is the order?
Sorry. So, I have to. Why I am withdrawn?
Where is the court's order?
I'm kindly. I was under impression that I will get pension. As per order of the honorable court, I have.
You sought for refund. The money has been refunded to you. Again, you want to go back?
Well, kindly see the page 29. The authority said that you will not allow since you have deposited money delayed.
Yes.
Now the division bench is allowed. The as per Mukti Pal, I can see.
What Mukti Mohipal? You take back your money.
Take back why? I have deposited money through Treasury Channel after the cut-off. Now the cut-off date is lordship the division bench. That
is it your case that you exercised option
within time?
In 1990.
1990, yes. That's it. That is also my case. That's page 22, 23, 22. First, not only 1999, that is 98. 22. Next page, as per over 98, that is 99. Oh, effect 98. All ROPAs I have exercised. This is, and not only that, ROPA 1998 as well as the circular dated. My fault is he could not due to his financial crisis.
Now you'll be able to do it with additional interest.
That is now all are
be able to do it.
All are getting. That's why he.
So you have to collect money and refund. That is important.
He has to. He will do that. He has to deposit all. Already amount calculated. That is the tier channel already. The
now that calculation will not do.
Interest will be added.
Interest will be added
only after retirement. That amount deposited up to retirement, that is calculated. Only that during this period.
Hey, Pradeep,
Oh,
CPF to GPF applying Mukti Mohipal.
that's why I said, sir,
কি দিচ্ছ?
only data is given and some. Also insert already 2014 circle.
Very well. Take this back.
ওরাটা দিয়ে
এটা ফেরত।
get full মাত্র every sir আমার নাম
এই প্রদীপ next.
Then I am for the question.
Yes.
My lordship, petitioner is paying area pension from the date of death of her husband till the date of refund, lordship. Earlier, petitioner filed it application as husband was the CP body for receiving pension and to refund the employer with interest. In
That
terms
has
of
been
the
done.
court order, lordship,
But the husband died.
died in harness.
Husband died in harness.
Before publication of the notification, lordship.
All right.
Which the petitioner filed application and in terms of the court order, PPO issued from the date of deposition of money. Sanctioning pension, lordship. Now I am paying the area pension from the date of death of her husband till the date of refund. That I have corrected, lordship. Order, lordship.
From the date. Where is the calculation of the money to be refunded?
Calculation not annexed here, but TR form is annexed here.
TR is annexed?
Yes, lordship. Page 28.
Please come, Pradeep. Take down in paragraph number 6. The petitioner refunded the amount as calculated by the authority by way of TR challan in July 2023. পড়তে পারছি না 8 না 18 না 10 আমি পড়তে পারছি না July 2023. PPO was issued in favor of the employee. The refund of the period after release from the next date of death. Disposed.
See, here also same prayer, lordship. I have corrected, lordship. Her petitioner husband retired, thereafter died.
Where is the PPO?
PPO 29.
28 is the TR challan.
29.
29 Date is
in July 2023.
cannot read. কিছুই তো করতে পারছি না।
Right side, serial number 9.
Serial number 9.
Right side of the PPO.
Show it to me. From there, please show which portion. 2023. Paragraph 6, page 28. 6 July 2023. DPO directed the petitioner to refund along with interest which the petitioner duly refunded. 7 ঠিক আছে। Which DI?
DI looks Paschim Medinipur.
Yes.
This is also same lot. Severe definition from the date of retirement till the date of refund of her.
Who is coming? The widow?
Widow.
Is this Purva Medinipur? Is this Purva Medinipur?
Paschim Medinipur DI lots.
Sure, it is Paschim.
Yes.
Your cost title, it is mentioned Purva.
Deciding at Purva Medinipur lots.
But then it will be DI is Paschim.
Yes, yes. It is got from the PPO lordship. Serial number 5. Pension Sanctioning Authority, Paschim Medinipur.
ঠিক আছে. All right.
Also same lordship.
For the state.
Same thing lordship. Widow is claiming area pension from the date of retirement to till the date of refund.
And the WP number is separate for everybody. Page 2, you've annexed a WP number. It is সবার আলাদা আছে তো? আমি বুঝতে পেরেছি সেই
Yes, my lord.
Paschim Medinipur.
Overdrawn on TR Chalan. Chalan is at page 18.
All right, same order.
Recognized.
My lord, petitioner is also died, my lord. Due to her old age, my lord.
Petitioner?
Died.
Died. And nobody wants to continue.
No.
Learned advocate for the petitioner submits upon instruction that the petitioner has expired during the pendency of the writ petition. Stop. In view of the above, the instant writ petition has become infructuous. The same stands dismissed.
Yes, Madam.
The heirs of the deceased petitioner are not inclined to proceed with the writ petition any further. Yes, next.
For the state, my lord.
This matter pertains to interest on arrear pension from CPF to GPF. In the same identical matter, the state has preferred an appeal before the appellate court, which is still pending.
Pending. Delisted for the time being. Yes.
The lordship petitioner herself, lordship petitioner is claiming arrear pension from the date of retirement to till the date of
Give. Date of retirement. Where is the PPO?
PPO lordship page 23.
23 was issued in 2005. Subsequent PPO?
2015 lordship. It is.
Which matter is this? Arati Chakraborty?
Arati Chakraborty. 16 June 2015.
No, this is 2005 PPO. এটাকে দেখান তো ওনাকে 2005 সালের PPO.
May be wrongly annexed, lordship.
Where is the correct PPO?
Yeah, lordship. Tendering apology, lordships.
All right, same order.
Great video.
ঠিক করে নেবেন. Yes.
I am for the petitioner, lordship. That
May I
petitioner
have for the state?
refund the lordship employer share with interest, lordship. I have corrected lordship order in terms of the Muktimoi lordship.
Which DI? Uliberia?
Howrah.
Howrah?
Yes, lordship. This one number 4.
Same order.
$523.
Huh? I'm for the 523 waiting, my lord.
Long gone, long gone.
24.
May I give my appearance, my lord? I was sitting, I was now 521 was called.
It has been upgraded long back. হয়ে গেছে তো? It has been disposed of. Check up in the server.
Oh, dispersed.
Yes.
Lordship, here the Lordship shortfall of service, Lordship.
How many days?
Delivery of service, Lordship.
How many days?
We are 5 months. And consider director to consider my representation.
Yes. Where is it?
It's
Page.
page 40.
Come. The petitioner seeks for seeks a prayer for consideration of his representation for condoning his pensionable for condoning the shortfall in his pensionable service period. Stop. The petitioner claims that he served as a part-time teacher on contractual basis for a certain period prior to his joining the school on regular basis. Stop. There has been shortfall in his service period. Stop. Prayer has been made to condone the same, relying on the law laid down by the Honorable Division Bench of this court. In the matter of, you got that, Kalipada, you've annexed?
No, Kartik Chandra Das.
Kartik, have you annexed?
Oh, no, Lordship.
Which matter you referred to today?
Lordship,
আজকে একটা অর্ডার নিয়েছে প্রদীপই মনে নিয়েছে কার্তিক চন্দ্র দাস এফএমএ
item number 497.
97
497.
হ্যাঁ 497 ঠিক আছে সেম অর্ডার হবে কনসিডারেশন অফ দি পিটিশনার্স রিপ্রেজেন্টেশন কতগুলো ইউজুয়াল অর্ডার আমি টিক মেরে দিয়েছি সেইগুলো থাকবে
Here is Kartik Chandra Das was the organizing teacher, Lordship.
Yes.
Here is petitioner is not organizing teacher.
Contractual principle is
Same, continuous
same.
service.
Yes. And appears on behalf of the petitioner at the time of call. For ends of justice, release the matter on 2nd of March.
But at 528, I appear for the petition.
I am for the state respondent.
This is my affidavit of service. But here, I retired from a DA getting school. I retired in 2018. I moved a writ petition before this court in 2019. I request your lordship to see page 18 once, 18. Page 19 is the operative part where the this honorable court, page 19. This honorable court had directed the headmaster of the school and the petitioner to sit with the DI and consider the representation which I made to the DI and to pass a result order. Now DI has passed a result order. Page 23 is the operative part. But I am relying on page 23, third paragraph from bottom, hence. Got it? Hence, in the light of the above aforesaid provision, so and so, the observation made by the Honorable Apex Court and having regard to the facts and circumstances, the petitioner is entitled to get relief as he prayed for. Then, since the issue of sanctioning of retired dues is subject of submission of requisite pension file, from the end of the school authority to the pension section authority. Following the formalities, the headmaster of the school is directed to submit the same within 2 weeks from so and so. Now, but this has been done. I am receiving pension. Now
What was the initial problem?
But the initial problem was pension, gratuity, nothing has been paid, and the arrear salary. Now pension has been paid. After that, I made a representation. Now the school has questioned this order of the DI before the High Court. Kindly turns to page 55. They challenged the order of the DI before the High Court. They themselves withdraw it. Page 55 is the order of withdrawal. Now, your Lordship, can have a look at page 56. I made a fresh representation for release of my salary for 12 months as well as my provident fund, which has not been paid. Now, it's a DA getting school. The school is the custodian of all these things. So, the copy has been served on the school. Writ petition has been served on the school.
In the last matter, I saw Mr. Torun Kumar Das appear.
Yes, Torun Das appeared. He usually appears for the school.
Today, nobody is here.
Shall I give him a notice and come back?
Please do. Otherwise, it may be a problem once again.
Yes. May I get a short date?
Yes.
Grateful.
The petitioner is a retired employee of a school staff. He prays for implementation of the direction passed by the District Inspector of Schools, Secondary Education, Kolkata on 22nd October 2019 at pages 21, 22 and 23 of the writ petition. At 20 to 23. So, submission of the petitioner is that though pension has been sanctioned in his favor, but the arrears salary and
the provident fund.
But
I'm sorry, the gratuity. The gratuity.
Gratuity is due and payable. Stop paragraph. The school is not represented. Stop. Let notice be served upon the learned advocate representing.
May I serve the school? It is in Kolkata, Borobajar. It is better. He may not appear.
For this school and the school authority also, intimating that the matter will appear in the list on 6th March 2026. Learned advocate representing the school shall apprise the court as to why the dues of the petitioner have not been disbursed till date, despite order being passed by the District Inspector of Schools.
I'm grateful.
Service is taken on record.
Grateful, my lord.
I'm appearing on behalf of his court.
I'm for the petition. Matter is leading to overdrawal. It is a challan overdrawal.
My lord, I have submit my instruction, my lord.
You retired in July 2022 and you refunded the amount in January in 2021.
29th December 2021.
29th of December 2021.
I have deposited treasury challan. Thereafter, PPO issued. Thereafter, I have returned 35.
Yes. So why will the amount be refunded? There has been excess HRA drawn by you. Excess house rent allowance drawn by you. Please come. Petitioner seeks for.
But Lord says, I have deposited the same through treasury challan before retirement.
Seeks for refund of the money deposited by her on account of overdrawn payment. Top paragraph. The petitioner retired from service on 31st of July 2022. Stop. The overdrawn amount was refunded by her through treasury challan on 29th of December 2021. Stop. The overdrawn amount was on account of excess house rent allowance drawn by her. Stop. The authority rectified the mistake well within the service tenure of the petitioner and directed her to refund the same, which the petitioner refunded in December 2021. Stop. The instant writ petition has been filed in July 2024, seeking refund of the said amount. Stop. The court is of the opinion that the employer has the right to rectify any error in pay fixation of the employee, and if direction is passed for refund, which the employee accepts, accepts well within the service tenure, thereafter filing writ petition more than 3 years after depositing the same cannot be allowed. Stop. The writ petition accordingly fails and is hereby dismissed. Instruction forwarded by the DISE, Paschim Bardhaman, signed on 2nd August 2024, be written with the records.
Versus in this meantime, COVID-19 one judgment passed by the Honorable Supreme Court and
Service
grace
is taken up.
period is February up to February 2022.
Yes, next.
But in this matter, I appear for the petition.
Led by query.
The area of provisional pension. But the fact remains that, my lord, the lady teacher retired on 3rd of December 2019. But during her service,
There is a direction for filing affidavit in opposition.
no affidavit.
My lord, I beg to appear for the school authority.
Lord, I would be relying upon my lord's own judgment. Lord, it's not the criminal case not relating to the school.
Which led to conviction.
Voted.
Put under challenge.
State.
Appeal is still pending.
Appeal pending.
Provisional টা চালু হয়েছে
Not the provisional of
Provisional pension, provident fund, gratuity, nothing has been paid.
provident fund has been paid, no gratuity.
No gratuity. Provisional pension.
Provisional pension was started from 21st of January 2025, much later the period of retirement.
There is a direction for releasing the provisional pension.
Yes.
So our instruction, this provisional has been started that much.
So, but from a later
O-
date,
only-
it should be
yes.
from the
Only
date
from
of
the school. Now DI had let's say state if they can clarify that what about the area.
You can clarify the area. The DI can always clarify.
Date of retirement.
That must then my mistake. I did not about this. I
Date of retirement is?
3rd December 2019.
3rd December 2019. And you got your provisional pension?
21st of January 2025 from onwards.
Pay the area of provisional pension at least. And what is the criminal case about?
Not the criminal case due to death of daughter-in-law.
498A?
498.
How is 498 related to the service?
My lord.
It's settled law. You cannot do that.
No, I'm the school. I have no objection. But
Oh, you are for the school.
And for the ADR, we shall write to the DI. Being the headmaster, will write to the DI.
Lord, this is the judgment, my lord's judgment. Lord, I am relying upon.
Please give.
Join to this.
No disciplinary proceeding
Nothing.
against you.
No pecuniary loss was reported.
Please come. The petitioner retired from service on attaining his normal age of superannuation on 31st of December 2019. Stop. Because of pendency of a criminal case against him, he has not been paid his terminal dues. Stop. Submission of the petitioner is that the criminal proceeding is no way related to the service of the petitioner. Stop. There is no allegation of pecuniary loss to the government. Stop. No disciplinary proceeding was ever initiated by the school against the petitioner. Stop. Paragraph. Whether terminal benefits of a retired employee can be withheld if the criminal case pending against him is not against her. আগেও হিম বলেছি কিন্তু her is does not have any nexus with the service has been decided by the court in the matter of এই যে এখান থেকে লিখে নেবেন তো অনাদি প্রসাদ মাহাতো reported in such and such and Gunamoy Mahato reported in such and such. Stop. Paragraph. Admittedly, in the instant case, there is no allegation of pecuniary loss of the school or the state by any act of the petitioner. Stop. The school is represented. Stop. The school did not initiate, the school never initiated any disciplinary proceeding against the petitioner. Stop. In view of the above, paragraph. The court video order dated 6th August 2024 directed the respondents to file affidavit in the matter. Stop. The same has not been filed till date. Stop. Direction was passed upon the District Inspector of Schools to release provisional pension in favor of the petitioner on compliance of necessary formalities. Stop. It has been submitted that provisional pension was issued on and from 21st of January 2025. Stop. The petitioner prays for releasing full terminal dues in her favor. Stop paragraph. Upon hearing the submission made on behalf of all the parties and on perusal of the materials in record, it appears that the petitioner would be covered by the law laid down in the matter of Anadi Prasad Mahato within bracket Supra and Gunamaya Mahato within bracket Supra. Stop. The court, while dealing a similar issue in WPA 6171 of 2022 within bracket Shukdev Haldar versus State of West Bengal and others, passed order on 10th May 2022 by observing that it can never be ascertained with certainty as to when the criminal case will come to an end. Stop paragraph. In the instant case, the criminal case against the petitioner was initiated in the year 2017. Stop. An appeal against the order passed by the trial court is pending consideration till date. Stop. The petitioner retired from service way back in 2019. Stop. The court does not find any reason to withhold the pensionary benefits / terminal relief of the petitioner. Stop. Next. In view of the above, the instant writ petition stands disposed of by directing the District Inspector of Schools. Which place? Malda?
Malda.
Secondary Education, Malda. To take necessary steps for releasing the complete terminal dues of the petitioner. Stop. Dues of the petitioner upon compliance of all necessary formalities. Stop. The school and the petitioner are directed to cooperate with the DI for the purpose of making the pension file of the petitioner ready. Stop. Steps shall be taken to release the dues of the petitioner positively within a period of 6 months from the date of communication of this order. The petitioner is directed to forward to the DI copy of all supporting documents in his favor for grant of terminal relief at the time of communicating the order of the court. Disposed.
Till such payment is made, the provisional pension should be
till complete disbursement of the terminal dues of the petitioner is made, comma, the provisional pension that is being paid to the petitioner shall continue.
Along with the arrears.
All right.
Along
Obviously.
with
Arrears means it goes from the date of your retirement. What
Right,
was the
okay.
can for? Can
that is the application for benefits.
Can disposed. Yes.
Grateful, Your Lordship.
31, I am for the petitioner. This is my affidavit of service, Lordship. The Lordship petitioner claiming the revised benefit as per OPA 19, such as gratuity and commutation, and also trying to correct the name of the nominee, Lordship. Petitioner retired 2018. And petitioner first wife died 15 September 2010. And petitioner got second marriage lordship the 11 December 2019.
19?
19 lord.
10 he retired.
No, 10 died.
He retired?
He retired to 18. 28
After
February
retirement,
2018. After
marriage.
retirement, lordship.
And
There is
what
a circular,
about
lordship.
what about the heirs of the previous marriage?
One son.
One
There
son.
is the nominee in the PPO, lordship.
There is a circular 20th of March
Yes, yes, yes,
2006
post
clarification about definition of family of pensioner. আচ্ছা দেখুন তো 20 মার্চ 2006 আচ্ছা আমার কাছে রাখুন ফেরত দিন clarification on the definition of family pension including the post of retired spouse.
Another case, lordship. Your lordship pass and judgment to consider the petitioner case by the DBPG, lordship, and considering the case, lordship, also corrected the name and issued the PQ. There is another matter, lordship.
Let me see. Wife in case of a male pensioner. Where is your request for correction?
Request for correction, page 21.
Twenty-one. The petitioner prays for changing the name of his nominee in his service records. Stop. The petitioner is a retired teacher. Stop. He retired from service on 28th of February 2018. Stop. His earlier wife expired on 15th of September 2010. Stop. The petitioner remarried on 11th of December 2019. Stop. He prays for inclusion of the name of his post-retiral spouse in his service records. Stop. Reliance has been placed on the notification of the school education department dated, now being number 92, dated 20th March 2006, which permits inclusion of the name of post-retiral spouse of teachers in the service records. Stop. The representation made by the petitioner seeking such change is pending consideration in the office of the DPPG. Stop. Next. None represents the state respondents. Stop. In the absence of the state, it is not possible for the court to decide the issue conclusively. Stop. As it appears that there is a supporting notification in in support of the petitioner's prayer. Accordingly, the instant writ petition stands disposed of by directing the DPPG to take necessary steps to consider the petitioner's representation in the light of the notification mentioned herein above at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner immediately. Stop. If the prayer of the petitioner is allowed, the necessary correction shall be made in the service records of the petitioner without any further delay. That's me exposed.
Grant lordship ROPA 19 benefit also.
Granting ROPA 19 benefit is different.
I made two prayer lordship. One is
Prayer in one writ petition, how can it be done? And why has ROPA 19 not been granted? That is a separate cause of action.
maybe.
Why has ROPA 19 not been granted? That has nothing to do with the change of nominee.
Yes, lordship.
Then, the petitioner has a further prayer. Stop. He prays for grant of benefit under ROPA 19 in his favor. Stop. As the change of nominee and benefit under ROPA 19 are two completely separate issues, the same cannot be gone into in one writ petition. Adjudicated in one writ petition. Stop. Next. The instant writ petition is restricted only to the prayer of the petitioner seeking change of nominee. Stop. If the petitioner has any grievance regarding non-implementation of ROPA 19 in his favor, it will be open for the petitioner to file appropriate proceeding before the competent forum in accordance with law. Next.
Item number 532.
In this case, make it not to the lords. I am not prepared.
All right. We allow the learned advocate to come prepared, released on 2nd of March. Let notice be served upon the respondents.
Time for the petitioner lordship. Service lordship. Lordship, petitioner is the retired teacher. Petitioner during his service period, lordship, petitioner paid MS scale lordship. And lordship, that time petitioner CPA working. There are not petitioner exercise option as per notification and PPA issued. Lordship.
2014 notification.
Yes, lordship. PPA issued lordship. And thereafter the revised PPA also issued. Petitioner received the benefit of the PPA lordship. Now petitioner claim is lordship. Petitioner is not receiving pension as per last paid run of salary lordship.
To the last paid run.
Same. First, come to the page 30, service book. Last page 9,550.
9,550.
Lordship.
When did he retire?
Retired lordship. 31st July 1990.
99?
Yes, lordship.
Now, why are you coming now?
Lordship, the revised PP issue 2023, lordship. That is the.
Previously, were you getting pension in terms of the last paid run?
No, lordship. Primarily, petition was the CPA work.
After you convert to GPF, you.
Yes, lordship. Come to page 40, lordship, PPO.
Petitioner's prayer seeking grant of pension, relying on the last paid run by him, is pending consideration. Stop. None represents the state respondents. Stop. Affidavit of service is taken in record. Paragraph. In the absence of the any representation from the state, it is not possible for the court to decide the issue conclusively. Stop. In view of the above, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, South 24 Parganas to consider the petitioner's prayer. For grant of pension according to the last pay drawn by him at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Step. If any amount is found due and payable to the petitioner, comma, then revised PPO shall be issued without any further delay. Step. If the prayer of the petitioner is refused, comma, the ground for refusal shall be communicated to him. Learned advocate for the petitioner is directed to forward a copy of the representation seeking consideration along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court disposed.
534, my lord, I am appearing on behalf of the state.
It is also GPF area interest pending consideration before the division bench.
The issue is reported to be pending consideration before the Honorable Division Bench. Stop. Let the matter be delisted for the Stop. Liberty to mention.
Yeah.
My lord, 35 I'm paying for not today, my lord.
Aye.
My lord, it needs to prepare, my lord, again. One second, my lord. To prepare the matter, my lord.
Are you the advocate on record?
Yes, my lord.
You're not prepared.
My lord, this is a long pending matter came after long time, my lord.
So what? You must have drafted this?
Yes, my lord.
You have signed this? You must be knowing the facts of the case. What is the fact of the case?
My lord,
Yes.
the Honorable Coordinate Bench passed an order on 8th August 2023, my lord, page number 146, my lord.
Yes.
Wherein the District Inspector of School Secondary Education, Hooghly, was directed to consider the representation of the writ petitioner, which is in page number 108, my lord.
All right. Was it considered?
My lord, recent order passed on
30th of January 2024.
Recent order passed on 30th of January, my lord, page number 150, my lord.
Right. You are challenging
But,
this.
regarding the payment of interest, nothing was dealt with or considered with, my lord. After that, my lord, the petitioner filed contempt petition. Order of the contempt, my lord, page number 156.
Made to communicate. Amount. Page number 151.
Yes.
It appears that the petitioner accepted the deduction from his arrears. What is your...
Yes, my lord, that representation as page 108, what Honorable Court was pleased to direct to consider, my lord, it has this 150 has been passed in consideration there. This here, my lord, only this interest part, interest was claimed. My lord, the bare perusal of this reason order will say that since the arrear was paid after deduction of this mismatch amount, that has been credited to the petitioner's account. So, my lord, that's accordingly, if it is not said but arrear paid and there is no, it says
Arrear paid after delay. This is the reason.
delay. Yes, reason that, and the direction was to consider that it will say that that has been rejected by this reason order. My lord, kindly see the language, my lord. Thereafter, if we come to my lord,
Yes, it has
it's
been rejected, but what is the ground of rejection? See, paragraph numbers.
Yes, 6 to 8.
Right, 6 to 8.
8.
There is no ground. Allotment was given.
Yes.
Allotment
No,
was
that is
given.
that the chronological events were cited.
Right, but what is the ground for refusal?
My lord, this is the ground, my lord, that arrears were paid. This earlier the school authority.
Arrears paid, but at a delayed point of time. Why will interest not be allowed?
My lord, kindly sees, my lord, that inquiry report, the school authorities conduct, the school authority, my lord, this dismissed. My lord, this is
the order passed by the District Inspector of Schools, Secondary Education, Hooghly, dated 30th January 2024, is impugned in the instant writ petition. Stop. The prayer of the petitioner seeking interest on account of delayed payment of his dues is challenged. Stop paragraph. The DI SE Hooghly is directed to file a report as to why interest will not be paid to the petitioner on account of delayed payment of his dues. Stop. Such report shall be prepared and circulated by 20th of March, released on 6th April 2026. And an exception to the report may be filed by the petitioner prior to the adjourned date. Next.
affidavit or only simple report?
Report by way of an affidavit. Only say why interest will not be allowed. Yes.
And for the patient. Sorry. The overdraft clear challenge is at page 17.
How do you dispose? Same order.
41 also minus same.
Italian.
Challan is at page 17.
When did the petitioner retire?
Then I retired on 31st of October 2014, madam.
You refunded the amount in 2018.
2019, madam. 13/6/2019.
After retirement.
Yes, Lordship.
The PPO was issued in 2020.
Yes, Lordship.
And when was this intimated to you? Why after so many years? None appears on behalf of the respondents. Stop.
Madam, kindly see paragraph number 7, madam.
Yes. What is the paragraph number 7?
Whether the respondent authority, particularly the concerned district inspector of schools, asked to refund the amount for the reason stated in paragraph number 8A, my lordship. Paragraph number 8A of
The petitioner
TR
retired from service on 31st of October 2014. PPO was issued in his favor on 13th of February 2020. Stop. The petitioner submits that he was directed to refund certain amount after his retirement, which the petitioner did by way of filing by way of treasury challan on 13th of June 2019. Stop. The petitioner prays for refund of the amount. Paragraph. The state DI is directed to file a report disclosing its stand. Released. Disclosing its stand by 20th of March. Released 6th of April. Exception may be filed by the petitioner prior to the urgent date. Learned advocate for the petitioner is directed to communicate this order to the learned advocate representing the state and to the district inspector of schools. This will go back.
Number 545.
The money overdrawn by TR Challan. Challan is at page 17 and 18, my lord.
Same order will go down. Disposed.
Well, 48, my lord, I have the instruction to appear on behalf of the school authority. My lord, there are certain documents.
So, my lord, I am not get the pension, my lord, and also, my lord, the area salary, my lord.
He is not cooperating. My lord, my instruction is that, my lord, he is not cooperating. There is an allegation of defalcation against him.
Yes, my lord.
My lord, provisional pension was issued, my lord, granted on his favor. But subsequent to that, my lord, in the audit process, he is not cooperating. This is my instruction, and there is an order of magistrate also with that regard. My lord, may I come back with the documents, my lord?
Kindly come to page, my lord, 38, and it's a P3. The court is directed, my lord, to complete the audit report, my lord. Audit, my lord.
There is already a direction for appointment of auditor for completion of the audit Why has it not been
Auditor
done?
has been appointed. My lord, he is not cooperating with the my lord works he has done during his tenure. My lord, this is the only instruction I have. My lord, I don't have the document. My lord, may I come back with the document? My lord, keep it on Monday.
Please come. None appears on behalf of the state respondents.
My lord,
Stop.
Mr. Shamimul Bari appear for the statement.
Where is he?
My lord.
There is a direction for filing of the report. Where is the report? You are not ready with the brief?
Well, I missed the brief today. Well, can I take it tomorrow? Well,
There is a direction for filing of report
I will-
with advance copy.
well, I will see. Well, can I take it
Then?
tomorrow? Well, kindly. Or on Monday, madam. Tomorrow means Monday.
Video order dated 14th of February 2025. The court directed the DI to file a report in the form of affidavit.
Yeah, Muslim.
Stop. The affidavit has neither been filed nor served upon the learned advocate for the petitioner. Stop. The petitioner alleges non-release of his terminal dues. Stop. Learned advocate representing the school seeks time to revert with written instruction. Stop. Next. In view of such submission, release the matter for further consideration on 30th of March 2026. Stop. Report by the DI and the school shall be prepared and circulated by 20th of March 2026. It will be open for the petitioner to file exception to the report prior to the adjourned date. Stop. The audit of the school shall be completed at the earliest, comma, if not completed earlier.
Thank you.
But I am for the petition. May I file my recusal? My lord, petitioner came before this honorable court on earlier occasion. My lord, for my lord, shortfall of service in getting the my lord pension in event. My lord, page 70 is the order.
Reasoned order under challenge is 92.
Yes, yes.
They have
rejected only because of the fact that the shortfall of qualifying size is more than 6 months.
Yes.
Paragraph 9, page 90.
Right. And what is the reason for the shortfall?
Petitioner on earlier occasion came before this honorable court from 2002 to 2012 in getting the appointment letter. On litigation, the petitioner came before this honorable court. Kindly see the first order is at page 32. There is a dispute in regard to the preparation of panel by the school authority.
But then you had applied for condonation of shortfall after a lapse of 6 years.
After retirement.
6 years after retirement.
No.
What no?
I retired from service on 31st January 2019. Immediately thereafter, I applied for to the school authority. Another point I have taken, another similarly circumstanced person, came before this honorable court and the principal secretary, passed a reasoned order, allowing the pension in BTP, granting the PPO, issuing the PPO. I am covered by your losses,
No, you show me the litigation that was pending.
Kindly see the first annexure, page 28 onwards, relevant parties, page
It's the other side.
served,
You come back once again. Achan, the order passed by the Assistant Secretary, School Education Department. No, not assistant, Principal Secretary, School Education Department. On 17th of January 2025, rejecting the petitioner's prayer for condoning shortfall of his service period is impugned in the instant writ petition. Stop. The representation of the state will be required for effective adjudication of the instant list. Stop. None appears on behalf of the state. Affidavit of service is taken on record. Stop. Let a notice be served. Mr. Shuman Dev was here just now.
I am told by my client that he is appealing.
Yes, he was here just now. Let a notice be served upon Mr. Shuman Dev, learned advocate representing the state, intimating that the matter will appear in the list on 2nd March 2026.
My lord, just now Mr. Shuman they called me, my lord. He is engaged in the other call, my lord. He is praying for the Passover, my lord.
No Passover. Yes. Call next.
I am waiting for the state response, my lord.
Yes.
Here, petitioner primarily appointed para teacher, lordship, in the 2004. Thereafter, lordship, petitioner joined the regular school as a regular
Shortfall
teacher.
in service.
And the rejected the petitioner pair, that is page 59.
Yes. The shortfall of not completed 10 years, my lord.
How many days short?
3 years something. More than 3 years.
Only 6 years, 2 months served.
6 months can be considered, but my lord, 3 years.
How?
More than 9 years, I have served as para teacher, lordship.
Para teacher.
What can be done? Para teacher services can
it is,
be
my lord.
considered.
Service, lordship.
Maybe continuous. Show me that para teachers have been continuous service of para teacher can be allowed.
That type of judgment at the point of time I have no knowledge.
Then,
but lordship, it is the like the Kartik Chandra Das, Nimai Chatterjee, lordship.
yes. Continuous
Contractual service, my lord. Para teacher.
Continuous service.
Contractual year to year.
But in none of the matters it was para teacher.
Kindly allow my prayer because I have served for the nation, lordship, for 2004 to 13.
When you served for the nation, you were sure that you will not get pension because para teachers do not have pension. Right? Thereafter, you got job over here. It is not a case where litigations were pending for which there has been delay or something. So this is a different case. Maybe continuous, but
The contractual service also.
I cannot help. Please come. The petitioner is aggrieved by the reasoned order dated 17th of July 2023, rejecting the petitioner's prayer for condoning the shortfall in her service period. Pensionable service period.
So 1 second, lordship, the page 51, there is the circular, lordship, the government circular.
Yes. Aided or unaided institution shall be. You served as a para teacher. Will that help you?
Maybe helpful.
Para teacher is different. It is neither aided nor unaided.
Yes. Character they have been added only on temporary basis and contractual.
Shortfall of her pensionable service period. Stop. The petitioner relies on the Education Department within bracket budget branch memorandum being memo number 180 page 51. Please copy. Dated 20th March 1998. Which mentions that the that if the employee কি বললাম such and such memo number mentions that employees of unaided institution
and the contractual basis.
shall be counted towards pensionable service provided at the time of retirement the institution in which the incumbent served received aid from the government or any other body authorized by the government. Stop. Learned advocate for the petitioner submits that as the petitioner retired from an institution which is aided by the state, aided by the government, accordingly, the authority ought to count the service rendered by her as additional para-teacher in upper primary section of a school on contractual basis. Where she served for more than 9 years and 3 months. I think there are judgments in your favor. You bring those. Relying on this memo, possibly there are judgments. You bring.
My lord, in
Right.
MAT number so my lord, only 6 months can be considered by the government.
The to allow the learned advocate representing the petitioner to revert with judicial precedents in her favor, which permits the counting of past service in similar type of cases. Hearing of the writ petition stands adjourned till when can you come back?
After 2 weeks, let's say.
30th of March. Instruction forwarded by the DI Secondary Education Nodia dated 8th April 2025 be written with the records.
Next item also same. Also.
Next item, we'll take it up on the next day.
I was addressing your Lordship, my lord, on the point of quashing of the 4 FIRs. And my lord, I had started with the FIR number 397, and I was taking your Lordship through the charge sheet of that. Because my lord, that has the recording of facts of with regard to the investigation. So, my lord, I was at the placing, my lord, the supplementary affidavit, my lord, on behalf of the state in connection with Shakespeare Shoni PS case number 397 of 2013. One Kaushik Broto Mujumdar has. Now, my lord, I had shown to your Lordship, my lord, that initially the complaint is at page 6 of this affidavit. I had placed it. And my lord, I had shown that the petitioner was not an FIR named accused. In course of investigation, my lord, his role as far as the alleged offense is concerned, my lord, was found, and my lord, charge sheet was filed against the writ petitioner. Now, my lord, the charge sheet is starting at page 10 of the supplementary affidavit.
A4 কাগজ কিন্তু
A11K. Yes. Now, my lord, kindly comes to my lord the charge sheet at page. My lord, in this case, your lordship will also notice that there are about 77 proposed witnesses. Your lordship will get that at page 50. And my lord, your lordship will kindly remember that on the last occasion I had given a chart showing that for which purposes the delay has happened before the trial court. Chronologically, that how, my lord, almost 37 times the accused had taken time. Accused persons.
77.
77 is the number of proposed witnesses.
Yes.
At page 50, your lordship will find that. My lord, all these will ultimately culminate into the when I address the point of law, my lord. Because, my lord, the primary point of quashing which I have found, apart from the Bhajanlal points, my lord, is that there is considerable delay in the trial, and that is why, my lord, the writ petition coins a word of punishment by trial. I try to find that, my lord. It's a novel word, novel phraseology, my lord. Be that as it may, I'll address that point, my lord. My lord, kindly comes to page 51.
Yes.
The brief facts of the case is that on 11th November 2013 at about 4:30 hours, some of the accused persons being armed with deadly weapons like metal rods, lathi, criminally trespassed into premises number 9A Short Street by scaling the boundary wall of the said premises for grabbing the property forcefully, by ousting the inmates of the said premises with intention to inflict grievous injury upon them. The main iron gate of the said premises was under lock and key from the inside at that time. After the intruder snatched the key of the main iron gate from one of the security guards who was performing duty at that place at the intervening night of 10th November and 11th November, on being deployed by the inmates of the said premises. The intruder snatched the key from the security guards by putting them into life threat. One of the inmates, namely Ganesh Thakur, who used to reside at the meter room of the said premises, was also threatened by the intruders with dire consequences. After that, the intruders opened the main iron gate by key, and 15-20 intruders entered into the said premises. Some of the intruders entered into the room of Ratanlal Nahata and tried to oust the residents of the said room by putting them into life threat. Then the inmates of the said room, namely Shafiq Ahmed, alias Pappu,
and Mamta Agarwal chased them with guns and fired. On being chased out of fear, few of the intruders left the premises and rest of them took shelter inside a wooden hut situated inside the said premises at 9A Short Street. Subsequently, on being informed, police from Shakespeare Sharoni and other units came to the spot. After that, on being instigated by Mamta Agarwal, Shafiq Ahmed alias Pappu, with the help of Pramod Shahu, who is the driver of Mamta Agarwal, traced out the intruders inside the said wooden hut and fired upon them intentionally to kill them, resulting which two of the intruders, namely Piklu Acharji and Prosenjit De, sustained gunshot injuries and died, and three were injured for the same, and they were Partho Chatterjee, Jayanto Saha, and Kaushik Addi, accused serial numbers 9, 10, and 18 respectively. On the basis of the signed and recorded statement of Shafiq Ahmed alias Pappu, a case Vide section K2 case number 397 dated 11 November under sections 120B, 143, 149, 485, 458 and 459 IPC was indexed against the intruders and others who hatched up the whole plan for grabbing the said property. Well, in this hatching, the role of the writ petitioner comes, though he was not an intruder directly. A separate case has been indexed on the basis of the complaint of one of the intruders, namely Subroto Ghosh, Vide Shakespeare Sharoni PS case number 398, dated 11 November 13 under section 302, 307 and 34 and 25 and 27 of Arms Act against Mamta Agarwal, Shafiq Ahmed and the Pramod Shahu. Then we'll skip over the three short paragraphs, last paragraph of that page. Investigation further revealed that 9A Short Street is situated on the northern side of Short Street. There was a big iron-made gate at the entrance of the premises and a small gate was fixed on it. There was also a big courtyard which was surrounded by single-storied rooms in that premises. The said courtyard was divided into two parts by iron fencing. The front portion was covered with marble and the rear portion, that is the inner side, was covered with sand and grass. On the courtyard, there were small plants, flower tubs, plastic-made articles for children. An iron-made staircase goes up to the roof of the meter room, was placed in front of the said meter room, which was situated on the right side of the entrance. One broken wall was attached with the outside wall of the meter room. By climbing up the broken wall, one can easily enter into the premises when the main entrance door was closed from inside. On the opposite of that room, there was a room having a glass door, and a kitchen cum dining room was situated just in front of the room having glass door. 4 CCTV cameras were fitted at the different places of that premises. On the inner side of the said premises, a small red-colored wooden house with green-colored slanting roof was placed at the eastern side of the courtyard covered with sand and grass. That cottage had a small multicolored door and window leaves. There were other rooms in that premises. A doctor's chamber was attached with the said premises. Mamta Agarwal ran a school, Young Minds International School for children here. The classrooms of the school are divided by wooden partition wall and some portions by asbestos and tin shed. Mamta owns a white colored car which remains in the courtyard with marble flooring at night. The room of Ratanlal Nahata is situated on the northeast corner of the said premises, which is very much inside the premises. Pappu and Pramod also worked in the said premises. Generally, Pappu took Ratanlal and Pramod drives the car of Mamta. They also assist Mamta in running the school. Pappu, Pramod and Mamta along with their cook, sweeper and maid resided in that premises. Apart from the family members of the attendant of Dr. Moore, one Darwan cum attendant Ganesh Thakur also stayed at the meter room but used to work at different places. Then again skips over 2 paragraphs during investigation. Inculpatory statements made by the above noted accused number 5 Keshav Shamol, accused number 7 Partho Chatterjee, accused number 10 Pinakesh Dotto and accused number 11 Rajesh Damani were recorded under section 164 CRPC on different dates. Therein they also stated the conspiracy and role played by each of them accused person in connection with the case. Investigation further revealed that one Rajendra Sain, these I have already given a flow chart on the last occasion. Investigation further revealed that one Rajendra Sain, son of so-and-so of 27 Madan Mitra Lane, Kolkata, was the owner of 9A Short Street before 1999. After the death of Rajendranath Sain, the ownership inherited to his widow Shailobala Sai of the same address and they had no issues. On 21st or 22nd June 1999, being the director of Heartline Estate Private Limited, the then Mumbai-based company, one Dilip Das, son of so-and-so, purchased the said property by way of a sale deed from one Shivaji Banerjee of so-and-so, claiming to have power of attorney issued in this favor by the said Shoilobala Shai. Darukanath Shai, nephew of Shoilobala Shai of 27 Madan Mitra Lane, received 9.5 lakhs on behalf of Shoilobala Shai from Heartline Estate Private Limited for the same. Shoilobala Shai executed her last will, not probated, on 23rd December 2003 in favor of her granddaughters Rakhi and Rumi Shai, daughter of so-and-so, Darukanath Shai, before her death in the year 2008. Subsequently, the said Rumi and Rakhi sold the said property to one Ratanlal Nahata by way of deed of conveyance on 14th of August 2010, amounting to rupees 1 crore and 41 lakhs. On the other hand, the directors of Heartline Estate Private Limited, said Dilip Das and one Rajesh Damani, son of so-and-so, sold the property by way of two deeds of conveyance to one Sanjay Surekha, son of so-and-so, and his wife Sapna Surekha on 29 September 2010 for amount of rupees 8 crores. Two original deeds of conveyance were made. Subsequently, the said property is mutated in Kolkata Municipal Corporation in the name of Sanjay and Sapna Surekha on 19 September 2013. Heartline Estates Private Limited sold the property to Sanjay Surekha and Sapna by way of two deed of conveyances registered at the Register of Assurances for a total consideration of 8 crores in the year 2010. In these two deeds of conveyance of 2010, one Parag Majmudar of Ritman Commercial Private Limited and one Ajay Modi of Sriji Flatholders Private Limited signed as confirming parties. A total of 8 crores was paid by Sanjay Surekha and Sapna Surekha by mode of RTGS in the following manner: 3.5 crore to Heartline Estates, 1.73 to Ritman Commercial Private Limited, 2 crores to Sriji Flatholders Private Limited, and rest 0.71 crores was paid to RA Kolkata towards the registration fees. Parag Majmudar, in that transaction, his company took 1.73 crores. That is serial number 2. From the amount of 3.54 crores mentioned in serial number 1, the major amount of 1.40 crore was transferred to Lansing Investment Private Limited. An amount of 2 crore was further transferred to Ritman Commercial Private Limited. Therefore, 1.73 plus 2 crores goes to Ritman. From this flow of money, it is found that the most of the money received from the Surekhas were settled into the accounts of Lansing Investment Private Limited, Ritman Commercial Private Limited, and Sriji Flatholders Private Limited. In all the above named companies, Parag Majmudar and his wife Falguni Majmudar are common directors. During investigation from the statement of Dilip Das, director of Heartline Estate Private Limited, it could be learned that Parag Majmudar, being the director of the companies where the money ultimately settled, was the mastermind behind the offense of criminal trespass, out of which the case under reference was raised. As in the deed of conveyance between the Surekhas and the Heartline Estate, Parag Majmudar stood as the confirming party and also received consideration of 3.73 crores in the two accounts, which is Ritman Commercial Private Limited and Sriji Flat Owners Private Limited, also received rupees 3.40 crores from the account of Heartline Estate with ICICI Bank NS Road branch. So it is clear from the aforesaid facts of monetary transaction that Parag Majmudar is the person who took the total of 7.13 crores out of the 8 crore for the sale of land by Heartline to the Surekhas. But as a matter of fact, the land in question for which he took that money could not be handed over to the Surekhas even after a lapse of 3 years or more, and he was not at all in the position to hand over the said land to the Surekhas since the date of execution of the deed of the conveyance. This is the reason he hatched up the conspiracy with others.
How does 7.13 comes? 3.73 is all right, I see it.
3.73 plus minus 3.40.
He took that also?
Yes, Manoj, kindly sees the second paragraph after the heading. In
Yes.
all the above companies, Parag Majmudar and his wife Falguni are common directors.
Yes.
So, Manoj, both the companies, director is Parag Majmudar. So, through various channels and names, ultimately the money is landing up with Parag Majmudar.
Heartline,
Ritman and Swiji, not Heartline. Apart from Heartline, Lansing, Ritman and Sriji. Well, kindly goes back to the para A. Para A, under the heading. Kindly text before that. 3.5 crore goes to Heartline Estate, 1.73 to Ritman Commercial, 2 crores to Sriji flat holders. This much. Remaining goes to RA. So, Malat 7.13. The major amount of 1.40 was transferred to Lansing out of, now this is out of the 3.54. Because Ritman already Parag is there. Sriji already Parag is there. So now Heartline kindly sees out of the 3.50, 1.40 was transferred to Lansing Investment. An amount of 2 crore was further transferred to Ritman Commercial. So 3.50 is split between the Lansing and Ritman. Now, Malad, in Lansing, Ritman as well as Sriji, all three the director is Parag Majmudar. So through various channels, ultimately the money flows into his coffers. Then kindly sees that line, in all the above companies, Parag Majmudar and his wife Falguni are common directors.
Yes.
Now the reason he could not hand over the property is mentioned in the first paragraph of that. This is the reason he hashed up the conspiracy with others. Stop. Then next, requisitions were made to the Register of Companies to know the actual director or managing director of 25 companies owned by Parag Majmudar and his wife Falguni Majmudar. There is a long-standing dispute over the actual ownership of the premises number 9A Shaw Street, and several criminal cases and civil suits are pending before different courts, including the Honorable High Court, Calcutta. For the last 3 to 4 years, a group of people under the leadership of Parag Majmudar, accused number 11, Rajesh Damani, accused number 13, etc., were trying to oust Ratanlal Nahata and other inmates from that place. They appointed Pinakesh Dotto, accused number 12, Partho Chatterjee, accused number 9, and Samir Riaz, accused number 14, and others from the time to time for capturing the land smoothly. In this regard, several criminal cases, being Shakespeare Sharoni PS case number 150 of 11, 314 of 13. This is one of the cases before your lordship. Shakespeare Sharoni PS case number 340 of 13. This is also before your lordship. And Shakespeare Sharoni PS 388 of 13 were recorded at the local PS, and investigation of those cases are going on, except Shakespeare Sharoni PS number 150 of 11, which was declared FRT on 14 November 2011, and civil suit VD CS number 41 of 2011 is pending before the Honorable High Court at Calcutta. During the course of investigation, it was learned that Parag Majmudar is the businessman, deals with construction. He is well acquainted with the conspiracy, plan of action, and money transaction into this gruesome offense. He is the financer of the whole operation, which draws a devastating end. He engaged Pinakesh for ousting Ratanlal Nahata and other inmates of the PO. The whole operation was done under his direction. He is the principal conspirator. Pinakesh has been paid rupees 1.5 crore by Parag Majmudar to take possession of 9A Shaw Street and to oust the inmates of the said premises. On 16 November 13, pursuant to the statement of the above noted accused number 12 Pinakesh Dotto, and on being brought out by him, the key of vault number 73 of Vijaya Bank Jadavpur branch was seized from his house. Thereafter, being led by him and to the said bank, cash money amounting to 82 lakhs was recovered and seized from inside his said vault of the said branch. Two original deeds.
All this came from the.
It came from Pinakesh, who was paid 1.5 crore by Parag Majmudar, according to our investigation. Two original deeds of conveyance were seized, where question signatures of accused Parag were present as confirming party. He visited the place of occurrence several times to negotiate with Ratanlal Nahata and Mamta Agarwal. He threatened Ratanlal Nahata and Mamta Agarwal to leave the said land. On the first week of November, he decided to put extreme pressure on Ratan and Mamta by sending the bouncers and security guards. After that incident, Pinakesh contacted him to inform what was happened. Accused Parag Majmudar played a key role, main beneficiary in the transaction in the land deal. He engaged Rajesh Damani to be the director of Heartline Estate Private Limited. He assured him to give remuneration for that. Rajesh and one Dilip Das were the directors of Heartline Estate Private Limited. Those were under the control of him, Parag. But the all in all was Parag Majmudar. It is further revealed that on the fateful night, accused Pinakesh Dotto along with Partho Chatterjee and absconding accused Arup Devnath collected all the bouncers, lady security guards from different places and assembled them in several lodges, which is Chaya Neer, situated at so-and-so, Madhuri House, situated at so-and-so, Dhaka Villa, situated at so-and-so, Shomrat Guest House, situated at so-and-so, Guest House style Shonar Bangla, situated at so-and-so, and transported them to 9A Short Street in their hired vehicles. After that, some of them scaled the boundary wall of the PO and went to the roof of the eastern side rooms, and from there entered into the compound of the premises through the iron-made staircase, armed with iron rods and lathi, etc. After that, they went to a small room situated at the eastern side in search of keys of the main gate. There they found one inmate of the said premises whom they threatened to kill if he did not hand over the keys of the main entrance gate. Being scared, Ganesh Thakur informed them that the security guards are inside the car parked inside the said premises and the keys are lying with them. Then those intruders, on the point of life threat, captured the said keys from the security guards. After they opened the main entrance door with the help of those keys, after opening the gate, 15-20 people, including 4 ladies wearing uniform security guard, entered the said premises, and Pinakesh Dotto, Shomir Riaz, Arup Devna remained present inside those hired vehicles parked outside the premises. Lights were glowing inside the said premises as well as on the short street. Thereafter, some of those intruders went inside the room of Ratanlal Lahata and found Mamta Agarwal, Shafiq, along with Ratanlal, and told them to leave the place immediately as they were already taken the possession of the said premises on behalf of Parag Majmudar. Then Mamta Agarwal and Shafiq Ahmed pointed licensed guns of Ratanlal Lahata towards those persons, and then they were left the said room, and soon after that Mamta fired one round from the room, resulting which the glass door panes were broken, and one of the bouncers, namely Joyanto Shah, received injuries on his eyes by those broken glass articles. After hearing the sound, few of the intruders ran away from the premises and remaining took shelter in a small wooden hut situated on the eastern side of the rear portion of the courtyard. After that, Mamta, along with others, started firing. Mamta was instigating Shafiq Ahmed Pappu and Pramod Shahu, who is the driver of Mamta Agarwal, to find those intruders and to kill them. Subsequently, on being informed, police from Shakespeare Shawani PS and other units came to spot. After that, on being instigated by Mamta, Shafiq and Pappu with the help of Pramod, traced out the intruders inside the wooden hut and fired upon them intentionally to kill them, resulting which 2 of the intruders sustained gunshot injuries and died, and 3 were injured for the same. The injured persons were removed to SSKM for treatment, where 2 of them, namely Piklu and Prosenjit, were declared brought dead. Among the rest, some were admitted or treated and discharged. During the course of investigation, it is revealed that one police officer of the Shakespeare Shawani PS, namely Noor Ali, was closely associated with the main conspirator, that is Parag Majmudar, Pinakesh Dotto, Shamir Riaz, etc. And he was well conversant of the fact that those intruders would intrude into the premises, and for that he deliberately made some false GD entry on 10th of November 2013, which states that 2 constables were posted at 9A Short Street to avoid any untoward incident. But in reality, those 2 constables were not at all sent to the PO, as they were not at all informed about the said duties, as they were permitted to leave the PS for their personal work. Moreover, from the call details, it is learned that several phone calls between Noor Ali and Samir Riaz were made from both ends just before the incident, around the time of the incident, and even on the following day of the incident, when the police were searching for Samir Riaz badly to apprehend him in this case. Noor Ali did not divulge that matter to anyone. On 11 November, at about 1450 hours, the above noted accused numbers 1 to 9 were arrested from 9A Short Street after observing all legal formalities. The above noted accused number 6 to 8 were also arrested after observing all formalities, and accused number 10 was arrested from in front of SSKM on 11th of November at 22:15 hours. During the course of investigation and acting upon credible source information, the above noted accused person, namely Parag Majmudar, was arrested while he was in the mood of fleeing from Kolkata to avoid arrest in front of the security hold area near the check-in counter of Jet Airways at the departure level of the domestic terminal, first floor of NSCBI Airport, Kolkata on 13 November. Then so-and-so was seized, They kindly skips over to 3 paragraphs. During the course of investigation, acting upon credible source information, accused number 12, Pinakesh Dotto, was arrested from Bankshal Street near the crossing of Bankshal Street and Hare Street on 14th November. Then so and so. Second last paragraph. Accused number 7, Partha Chatterjee and Pinakesh Dotto, in their confessional statement under section 164 specifically mentioned the name of Shamir Riaz, who was an advocate of Bankshal Court, Calcutta. He played the vital role behind the gruesome offense. During the course of investigation, acting upon credible source information, accused persons Shamir Riaz was arrested in front of Bankshal Court on 11th December at about 14:30 hours. During course of investigation, Noor Ali was called to the homicide squad, detective department, Lal Bazar, for interrogation, and then after prolonged interrogation, arrested from inside the office of the homicide squad, Lal Bazar, on 13th of December 2013. Then, normal omnibus paragraphs. Investigation of the case was completed and prima facie charge has been established against these 25 persons, including Parag Majmudar. So, this charge sheet spells out the entire details in which according to our investigation, the conspiracy took place and it was executed for the happenings of the 11th of November, intervening nights of 10th and 11th November. Now, if your lordship kindly comes back to page 10, or the charge sheet also says so, either way, it is there at page 58 also, the charge sheet is filed under section 120B, 143, 149, 458 and 459. So, if your lordship kindly takes the IPC ones.
Page 58, you said?
Page 58, your lordship will find the sections at second last paragraphs, third last line. Same is there at page 10 also, which is the top sheet of the charge sheet.
IPC টা আছে এখানে
First kindly take 120B.
Yes.
Well, it is punishment for criminal conspiracy, that whoever is a party to a criminal conspiracy to commit an offense punishable with death, imprisonment for life, or rigorous imprisonment for a term of 2 years or upward shall, where no express provision is made in this code for the punishment of such a conspiracy, be punished in the same manner as if he had abated such offense. Whoever is a party to a criminal conspiracy other than a conspiracy to commit an offense punishable under so and so, that is for 6 months. Then kindly takes 141.
143.
141 has to be read, For 143 is the punishment for 141. So 41 kindly takes.
Unlawful assembly.
Unlawful assembly, an assembly for 5 or more persons is designated as unlawful assembly if the common object of the person composing the assembly is to overawe by force so and so, any that is not kindly sees. Third, to commit any mischief or criminal trespass or other offense. Then fourth, by means of criminal force or show of criminal force to any person, to take or obtain possession of any property or to deprive any person of their enjoyment of a right of way or the use of water, incorporeal right which he is in possession or enjoyment, or to enforce any right or supposed right. So, these will be applicable in our case. Then kindly text 143. Whoever is a member of an unlawful assembly shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine, or with both. Then 149 is every member of unlawful assembly guilty of offense committed in the prosecution of the same object. Now, I'm not reading the text of it, every member will be equally liable for this. Then 458. Lurking house trespass. Whoever commits lurking house trespass is at 443. 443 is the definition. 443 and 444, that whoever commits house trespass having taken precautions to conceal such house trespass from some person who has a right to exclude or eject the trespassers from the building, tent or vessel which is subject of the trespass is said to commit lurking house trespass. And lurking house trespass by night is whoever commits lurking house trespass at the night time. Read with that, 458. Whoever commits lurking house trespass by night or house trespass by housebreaking by night, having made preparations for causing hurt to any person or for assaulting any person or for wrongfully restraining any person or for putting any person in fear of hurt or of assault or wrongful restraint shall be punished with imprisonment of either description for a term which may extend to 14 years and shall be liable to fine. And 459, that is causing grievous hurt while committing lurking house trespass or housebreaking. Now, in the charge sheet, your lordship has found that the conspiracy has been elaborately discussed, what we have found from the investigation. Now, the unlawful assembly has also been stated. It is there in the complaint also, it is there in the charge sheet also. The lurking house trespass, is also with the preparation, after preparation for causing hurt, assault or wrongful restraint is also evident from the complaint as well as from the charge sheet. If your lordship remembers the statement of Shafiq, which is here at page 7, second page of the statement. Towards the middle,
yes,
towards the middle,
recorded
she said that we are under attack. I also came out and saw 10-12 persons, including few ladies, assembled in our compound, and they were armed with sticks and iron rods. The preparation was there for causing hurt, which attracted 458. And in the meantime, Pramod was sleeping at the schoolroom and he took sticks and chased them. But some of them were not leaving the premises, so we took the licensed gun of Ratanji and chased them. They ran away, and this took shelter in the wooden hut, and some went out of the property. If I would not chase them, they would have harmed. Then Mamtaji called police, and police came so and so. The preparation was there with sticks and rods by which they entered for causing the lurking house trespass. And from the investigation also, as has been recorded in the charge sheet which has been filed, they took the keys also by force from the security guards, where this 459 also comes into the picture. Therefore, in course of investigation, the conspiracy of Parag Majmudar and the conspiracy to cause these events is also borne out. Therefore, as far as 397 is concerned, as far as the parameters of quashing, I'll address all four together. But on the face of it, it is not a case where these offenses are not made out at all, number one. Or number two, Parag Majmudar is so distant from the allegations that no layman can think of his involvement in the alleged offense. He is absolutely, my lord, his hands are absolutely in the entire conspiracy. The entire money flow is in his accounts. And my lord, even in the confessional statements of others, corroborated by the fact that the money is coming into his account, the confessional statements also say that the conspiracy was by Parag Majmudar. And he has been mentioned in the charge sheet as the, first of all, the primary orchestrator and also the primary beneficiary of the entire transaction. Now, my lord, this 397 is the culmination of previous few attempts to take over possession of this same property. It is the third attempt, in fact. Now, my lord, initially, your lordship will kindly see a complaint dated 19th of August 2013, which ultimately culminated into FIR number 314 of the Shakespeare Shawani PS. That was the first in line. It was supplement. Two other supplementary affidavits has been filed. One is titled as PS case number 314. If your lordship will kindly take that.
Yes.
No, এইটা কোথায়? না, এটা তো নয়। এটা তো অন্য। এটাও 19 নম্বর, এটাও 19 নম্বর, এটাই কমপ্লেন্ট। এটা কোথায়? এটা দেখো না কোথায় আছে, এটা একটা জজ পড়াতে হবে এটা। কোন দেখো আমাদের অপোজিশনে কোথাও আছে কিনা। First kindly takes in that page 6. This is subsequent to the complaint. I'm just trying to find it. I have it. এইটা দেখো, এটাই তো কমপ্লেন্ট। রিটে বা অ্যাপ্লিকেশন আছে না, বা কাইন্ডলি গিভ মি ওয়ান। ক্যান 4 এ দেখো, ক্যান 4 আছে কিনা দেখো। Page 6 minute, your lordship has taken page 6 minute. Though this is not the complaint actually.
Page 6 of
The
14.
3 supplementary affidavit, PS case number 314 of 2013. But a complaint, I'm trying to find out, but it must be in one of the documents.
All right.
I have it with me in soft form.
All right.
না, এটাতেই হয়েছিল, এটাতেই কমপ্লেন হয়েছিল। I am providing you with a copy of the medical report from Calcutta National Medical College and Hospital as further document in respect of my complaint dated 19th of August 2013. That I am providing you with a copy of my medical report from Calcutta National Medical College and Hospital as further document in respect of my complaint dated 19th of August of Shakespeare Shawani PS. As you can see from my medical report, Kaushik Sen, Parag Majmudar, Sant Kumar Junjunwala and their men and agents attacked me with an iron rod and fractured my foot right. I have received due treatment at the said hospital along with X-ray and medication. The said person touches my body and outrage my modesty in front of people. They pushed me very hard and hurt my chest and shoulder. I request you to kindly draw my FIR to the above said effect and send a copy of the same to me immediately. Please take immediate action as my life is in danger and I can be murdered by these men at any given time. I have written ample number of letters to the Kolkata police authorities for the safety of my life, but no action has been taken by the police authorities. Today I have been physically assaulted by the grievously threatened by being murdered by these men, and under these circumstances I can only beg you to take quick action for my safety of life, else I shall be compelled to move court of competent jurisdiction, including moving to the flight. So, my lord, the complaint, which is also dated 19th of August 2013, my lord, culminated into this FIR of 314. My lord, may I just read out the complaint, my lord, because without, my lord, I'm searching for the copy of it, my lord. We might have missed it in the supplementary affidavit.
Complaint of?
This is a complaint of Mamta Agarwal dated 19th of August, which resulted in the FIR number 314.
This is the complaint.
This is after the complaint, she came again to give the medical documents.
All right.
This is that letter.
Oh.
Because your lordship kindly sees.
So there must be
written complaint. এটা না? হ্যাঁ, এটা কোথায় আছে? এটা কি
116 of can 4.
But kindly take 116 of can 4.
Not only 3 months.
complaint of Mamta.
Complaint
The
of
first
Mamta.
initial complaint prior to page 6 of this affidavit.
Yes.
Yes.
Well, I hope page 118 is legible, my lord, in your lordship's copy.
I have not checked up. You can read.
Very well, my lord. But this is, I'm reading from page 117 of can 4. But I'll try to highlight, my lord, the important parts. Subject is severe damage to property and removal of granite nameplate of Sri Dwarkanath Shrine and Omyonath Shrine of 9B plus C Short Street, Kolkata 16. On my protest was pushed back and hit with an iron rod on my foot, which is bleeding and swollen right now. And I was given grievous threats, criminal intimidation, and I was wrongfully restrained and physically touched by one Kaushik Sen, Parag Majmudar, Sant Kumar Jhunjhunwala, and their men and agents. It is important to bring to your urgent notice that a 226 is already pending at the Honorable High Court, Kolkata, regarding the said property, and there is a court order also. Respected sir, this was the subject. Respected sir, I am Mamta Agarwal, age 36, residing at 9B and C Short Street. I run my kindergarten school at 9A Short Street, which is just beside the said property 9B and C Short Street. Sir, I am a tenant at 9B, 9C Short Street under the landlords. For the past few months, there has been a lot of problems and trouble at 9B and C Short Street, and several gundas of one Kaushik Sen, Parag Majmudar, Sant Kumar Jhunjhunwala, and their men and agents have been threatening to kill me, and I am not giving in to their demands, and in this regard, I have written several letters to the police authorities of Kolkata and the Home Department and also the Governor West Bengal, Government of West Bengal. Also, my landlord Sri Dwarkanath Shrine has a pending 226 regarding the property 9B and 9C Short Street, Kolkata, with the Honorable Calcutta High Court. The said Kaushik Sen and Parag Majmudar have attacked me several times in order to kidnap and murder me in the last 2 years, and I have lodged several complaints and FIR, but nothing has been done for me. Again today means 19th of August. Again today at 11:40 AM, I was walking to my house at 9B and C Short Street from my school. I saw several men and agents of Kaushik Sen, Parag Majmudar, Sant Kumar Jhunjhunwala, and they themselves breaking the granite nameplate of Dwarkanath Sai and Omyonath Sai and putting their own white marble board. I tried to protest and stop them, and they pushed me back and hit my foot right with a iron rod, gave me grievous threats and criminal intimidation, wrongfully restrained me, and physically touched me. They said they will murder me for opposing for opening my mouth, and said Kaushik Sen will go to the local thana within brackets Shakespeare Shorni PS, and they will see what police can do. I desperately called up the Shakespeare Shorni PS, the DC South office, and the control room Lal Bazar to send police personnel immediately for help. Nothing could stop them, and they threatened me, damage the property, put a new marble board of theirs. Uh, Hit my right foot with a rod and left. By the time the police arrived, they left. I have clicked several pictures of the ruins and also of some men on my mobile phone, which I shall print today and provide to the police authorities. I am bleeding in my foot right now, and I shall go for a medical check and report after this complaint. But that is the page 6. As I didn't want to waste time, and I shall provide you with the same. Some other people were also present at the incident site, namely Shafiq Ahmed, Pramod Shahu, Akhil Haldar, who came when they heard me scream from the next door. Those are her employees. Sir, I am begging you and pleading you to help me and arrest all these men. Nothing stops them. They have no fear of Kolkata police authorities. They have no fear of the Honorable High Court. Sir, these people are a gang of criminals and politicians who will try to achieve their criminal goals by hook or crook, and I will lose my life in all these problems. These criminals can also do anything to my school and school children also. I will fight these criminals to save my life and my school and school so and so. These are not disclosing any offense. These men have attacked me and hit me, destroyed the property and damaged it, and most importantly, they have threatened to murder me and attack my school. Please, please, please help me. Sir, I shall provide the photographs from today's incident to you as early as possible along with my medical report. I beg you to please consider my complaint as an FIR and book these criminals under appropriate sections and oblige. But receiving this complaint, my lord, the FIR number 314 was registered, to which the subsequent letter of 6th of 19th August at page 6 and another letter by Darikanath Sai, who she says is my landlord, that is at page 5, was also attached to that case diary. But that is at page 5 of the supplementary. Same, my lord, allegations of dire consequences, threats with dire consequences, etc. has been mentioned, my lord. Now, my lord, this FIR is registered, my lord, under 341, 300, that is for wrongful restraint, because she said that I was 314. Now we are on 314 dated 19th of August, which is one of the first attempts in grabbing the property. She says that there is a earlier complaint also, but the earlier complaint was finished if the FRT filed. So, my lord, I am not going into that. As far as we are concerned, this is the first complaint and also one of the matters which is challenged before your lordship. But, my lord, 314 and 340 are on different footings because the trial is going on. I had mentioned on the last occasion, my lord, there is a very recent judgment of the Supreme Court which says that like in our courts, where the petitions are not filed under 226 and 482 combined, but your lordships cannot interfere in a trial which is already going on, because that will amount to interfering with judicial orders in a 226 petition. Therefore, for interfering after the cognizance is taken, the petition must be under 482. I'll place the decision, my lord, once I complete the facts, my lord. So, my lord, this FIR of 314 of 2013 is registered in the Shakespeare Shoroni, my lord, under 341. Your lordship will get the, in my supplementary also it is there, and can 4 also it is there. Supplementary page 8 and can 4 page 116. 341 for wrongful restraint. As she said that I was restrained, that part of the complaint was there, my lord. Then under 324, which is hurt by dangerous weapons, because she was hit by a rod which ultimately resulted in her foot bleeding, right foot bleeding. Then 506 criminal intimidation that is mentioned in the subject as well as in the body of the complaint, and mischief causing damage. And also, my lord, 114 that the abettor present when the offense is committed, because she says that Parag Majmudar and Kaushik Sen was there. So, my lord, this has resulted in a charge sheet which is at page 9 of my supplementary affidavit on under all these sections under which the FIR was lodged. Now, this is pending trial. They have also, this is an admitted case that this is pending trial. My lord, the next incident is the FIR of 340, which is dated 16th of September 2013. Which is also in a separate supplementary affidavit pertaining to 340. The complaint is at page 5. This complaint is by the employee of Mamta Agarwal, Shafiq Ahmed.
All right.
At the very first line, your lordship will find that the complaint is against Parag Majmudar, Kaushik Sen, and about 50-60 heavily armed antisocials for committing housebreaking with intention to cause grievous hurt, murder, and committing theft of mobile phones and cash money of rupees 17,000 by putting us in fear and on gunpoint ransacked the entire premises, caused huge damage by rioting in so and so, them forming themselves in unlawful assembly with sticks, rods, and not legible, Mulad.
Yes.
Under most compelling circumstances, I, Shafiq Ahmed, caretaker of Young Mind International School at 9A Shaw Street, do hereby bring to your kind attention for taking immediate steps and necessary action. And address you as follows. That today at about 4:30 p.m., 50 to 60 antisocial elements, heavily armed with all kinds of dangerous weapons, including revolvers and sharp weapons, broke into our said school and went into a frenzy of destruction in the school premises and started assaulting all the staff members, which is Ganga Ghosh, Akhil Haldar, Pramod Shahu, and Ratanlal Nahata, and others in the most brutal manner, and caused severe hurt on their persons using dangerous weapons, revolver butt, and snatched the mobile phone number so and so, so and so, and so and so, and also committed dacoity of rupees 17,000 cash lying in the school office. They also took with them licensed revolver in the name of Ratanlal Nahata. They gave out threats of murdering the staff members and stated that they have been sent by Parag Majmudar and Kaushik Sen to vacate the premises by hook or by crook. All the staff members suffered serious injuries due to the indiscriminate fist and blows and lathi movements by the said gang of antisocials, and they caused huge damage to school property. And only when we started to shout, then the said gang of persons threw us out of the premises and again started beating us. But when we shouted loudly and people gathered, they left the premises with threats of coming back again with more force, and further threatened that no one will help us. In the same said circumstances, I request you to take stringent action against the said person and stop the lawlessness going on since so long and since so and so, sent by Parag Majmudar and Kaushik Sen. Kindly provide police picket and as they may come back and murder us. Malad, for this complaint of 19th of September, Malad, an FIR is registered. Your Lordship will find that at page 8 of this supplementary affidavit under section Malad 147, that is rioting with and causing force or violence by unlawful assembly. Then 148, that is rioting with deadly weapons. 149, which is the punishment thereof. 379, that is for theft, because the mobile phone, they have said that theft has occurred. 448 is the house trespass, and 427 is mischief causing damage, and 506 is the criminal intimidation. Now, Malad, the 3 pages I have read out, Malad, I can again point out, Malad, but all these offences on the face of it are made out in the complaint, and this writ petitioner is directly named at several places of the complaint, and the complaint starts by saying that this is a complaint against Parag Majmudar for causing this incident of September 2013. Malad, this also, Malad, a charge sheet, in this also a charge sheet is filed, which is at page 9 of the supplementary affidavit. And in this case also, Malad, here also, Malad, there are about 42 witnesses. And the Malad, similar, Malad, as I read from 397, similar history has been mentioned. Your Lordships will find the petitioner's name at page 22. Fourth paragraph. Sorry. But the history is same as 937. I'm not reading that, that Mr. Karan was pointing out. 22, fourth paragraph. Being frustrated, the accused Parag Majmudar, your Lordship, has found. Then thereafter on 15 September, next paragraph again, Malad. Then whatever I read from the complaint is again mentioned in that longish paragraph. What is there in the last paragraph is the subsequent event, because by that time the event has already taken place when the charge sheet was being filed. Then the investigation mentioned at page 23. Investigation revealed that a specific case, Vide Shakespeare Shawnee PS case number 296 of 6th July, is under investigation by Anti-Cheating Section Detective Department, wherein the registration of property of 9A Short Street in the Office of Registrar of Assurances, Mumbai, in the year 1999, by virtue of power of attorney of Shoilobala Shai, was challenged. Investigation also revealed that there was no existence of any office of Heartline Estate Private Limited at 15 Champaklal Industrial Estate, Mumbai 22. Moreover, the power of attorney of the deceased Shoilobala Shai could not be found in the office of the Registrar of Assurances, Mumbai, but the same should be with the deed of conveyance in the Registrar Office. During investigation of the instant case, principal accused Parag Majmudar was arrested. He was also placed before TI parade on 12th of December 2013 and 4th of January 2014, while witnesses also identified him in both the occasions in Presidency Correctional Home. Accused number 2, Pinakesh, was the main henchman of the main accused, serial number 1, Parag Majmudar. In pursuance of his statement, the means of conveyance, one Innova car bearing number so-and-so, was also recovered from Survey Park, PS area. He was reportedly paid a sum of rupees 1.5 crores by the accused, serial number 1, Parag Majmudar, for that work. Out of the said amount of rupees 82 lakhs was recovered from his locker. I have already read that part. Pursuant to the statement of accused Pinakesh Dotto, another accused, Ritik Deva, alias Bam, was also arrested, who reportedly arranged miscreants from different places of 24 Parganas North, brought them to Kolkata on the day of the incident. He was also identified in TI parade on 4th of January 2014 by the witnesses. Pursuant to the statement of accused Samir Riaz, accused Mohammad Usman of Kamarhati was arrested. Accused number 4 Usman admitted that he, along with other miscreants, were hired by Samir Riaz, and accused number 7 Zishan Khan of so-and-so, who is still absconding, and learned CMM Calcutta was also pleased to issue warrant of arrest against Zishan Khan. In pursuant to the above statement of Mohammad Usman, the robbed Webley Scott .32 bore revolver of Ratanlal Nahata, along with other incriminating materials, were recovered. He was also identified by 2 witnesses on 18th of January 2014. Accused number 5 Samir Riaz was direct complicity in the case. Accused number 2 Pinakesh Dotto admitted his direct involvement into the crime, and he made statement under section 164 before the learned magistrate on 30th November 2013, wherein he also mentioned the name of accused number 6 Samir Riaz, who took pivotal role for ousting the occupants of 9A Shaw Street by hook or crook, engaging hired henchmen of 24 Parganas in lieu of money. He was identified in TI parade on 18th of January 2014 by 2 witnesses. During investigation pursuant to statement of accused Mohammad Usman, Mohammad Rafiq alias Chacha, being another hired henchman, was also arrested from Kamarhati area, and 1 country-made improvised pistol loaded with magazine having 4 live cartridges in it was recovered from his possession, which he admittedly carried during the commission of the instant case. He was also identified in TI parade on 28th of January. Zishan Khan is still absconding. I'm skipping over that part. Several raids were conducted. Investigation revealed the means of conveyance of 1 sumo car number so-and-so was arranged by him for commission of the crime that entered 9A Shaw Street. Investigation also revealed that principal accused Parag Majmudar was asking power of attorney from the purchaser of 9A Shaw Street, being Sanjay Surekha, for selling the rights of the property to some new purchaser, since the said Sanjay Surekha withdrawn himself from the deal of the property in dispute, that is 9A Short Street. Sri Sanjay Surekha asked accused Parag Majmudar to introduce the new purchaser to him so that he could realize his dues of rupees 6.2 crores. Surekha declined to give power of attorney for sale to Parag, since he lost his trust upon him. Then the recoveries, and thereafter the accused number 1 to 6 judicial custody, etc. Now, this charge sheet is filed, as I said, under 120B, 148, 149, 395, 397, and 427. 506 and 25, 1B and 27 on the Arms Act. You also will remember in the complaint, it was said that they entered with revolvers. So, factually, I am left with Anandapur PS case number 188. But since I have already taken 314 and 340, in the 4 minutes that we have, may I place the judgment of the Honorable Supreme Court, because that will help us in not wasting time in dilating into 314 and 340. 25. Oh. This is reported in 2025 SCC Online SC 1948. একটা কপি থাকলো আমাদের 1948 of 2025 SCC Online SC 194. আচ্ছা কপি আছে কপিটা নিয়ে পাঠিয়ে দিচ্ছি। Kindly takes paragraph 7 and 9. Here the petitioners relied on this same bench's earlier decision of Nita Singh, saying that my case is similar to Nita Singh, therefore it was quashed in Nita Singh, kindly quash in my case. That is the brief facts required. Kindly take paragraph 7. The writ petition in Nita Singh Supra was only under Article 226 of the Constitution as evident from the first sentence of the relevant order. Moreover, a bare reading of paragraph 8 thereof reveals that the relevant bench's jurisdiction under Article 227 of the Constitution or 482 of the Criminal Procedure Code had not been invoked. Further still, the last sentence of the first paragraph records that cognizance of the offense had been taken by the relevant criminal court. It is in such circumstances that we had the occasion to uphold the order under challenge of the Allahabad High Court, whereby the writ petition only under Article 226 was held to have become infructuous by reason of subsequent events, relying on several authoritative pronouncements of this court, including the Constitution bench decisions. Then paragraph 9. However, in the present case, certainly the division bench could have examined the grievance of the petitioner for quashing of the FIR together with the charge sheet following it, as well as the cognizance taking order, if any, since the jurisdiction under section 528, which is akin to 482 of the BNSS was also invoked, and the relief claimed could have been suitably molded, subject of course to the requisite satisfaction of the court that an order of quashing is warranted on the facts and in the circumstances of the case. We have no hesitation to hold that the division bench did not have the jurisdiction to pass such an order as per the sitting list. Therefore, my lord, when it is under 482 conjoined with 226, then only your lordships can interfere with a judicial order passed in a criminal proceeding. So, my lord, 226 can be invoked for quashing only up to the stage that the cognizance is not taken. And that is perhaps the reason and this deliberate ploy by them to delay that before the lower court as far as 397 is concerned. Case number 397 is concerned. But that also, my lord, I have found, my lord, as back as in 1992, the Honorable Supreme Court has held that delay in trial, your lordship will have to consider at least 6 aspects, including one of the aspects being whether the accused was delaying the trial or not. Because the Supreme Court goes on to say that when the trial is delayed, it is not the prosecution which is helped, it is the accused which is helped, because the witnesses are lost and the documentary evidence is lost in the meantime. I'll place that, my lord, on the whenever your lordship keeps it, my lord. Perhaps your lordship will keep it on the Friday.
Check up the cost title. Is it only
226? I've checked. Both I've checked.
Cans.
No, stop.
Next Friday?
Friday.
Please come. Senate Council appearing for the state continues argument. Stuff fixed for further argument on 27th February.
Your lordship rises, my lord. Item 49 to 52, it was continuing, my lord, hearing that after expiry of appointment, that was continuing, my lord. I was commenting, can it be any day so that it can be finished? Otherwise, subject to your lordship's convenience today, but any day, your lordship.
See, next Friday also we have at 3:30.
3:30, and this matter will continue.
This matter is going to continue, and it's an assigned matter pending from quite some time. I tried to release, but the councils were not agreeable. So I had to continue.
I'll conclude as soon as possible. Your lordship has heard it considerably.
Thursdays are applications.
Even my
Lord was directed to file the affidavits also. We are for the respondents.
I was continuing with my argument. I will not take. I will finish by 45 to 1 hour, my lord. I will finish.
I'll take maximum half an hour.
3:15. any day, my lord, please.
All right, let me check up my list. You keep a watch on the list. এটাকে একটা stipulate